Mic check 1 2 1 2. Is it fine? Mic check 1 2 1 2.
Hello, 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 hello. Hello.
Can you hear me? Oh, my goodness. Oh, yeah.
Hello.
That's fine. What's up?
I don't know how to switch.
Two.
1, 2, 1, 2. Oops. 1, 2. Good morning. My name is Pusetso Morabedi. I am the Southern Africa Director for the Platform to Protect Whistleblowers in Africa, PLAF. And it's really, I always look forward to Whistleblower Protection Week since we started last year, and ones that were organized by ODEC back in 2011 and years before, because Whistleblower Protection Week is really about exchange. It's about sitting down and reflecting on, so trying to do some live streaming today. So sitting down and reflecting on what is, what ought to be, what needs to be corrected, what we can do to really support whistleblowers. And actually, it's really about what we can do to ensure that those who fight corruption get the protection that they need. And not only just protection, because by the time at times you bring in protection, it's already too late. It's about the support that they need before they even blow the whistle. What is needed legally, what is needed psychologically. Now we've gotten to learn that whistleblowing and the retaliations that come actually can have a toll on someone's mental health. So they've needed psychological support. As PLAF before, we only focus on legal assistance and strategic litigation, and we didn't think, people needed support, only to find out that actually that's where probably the core support needs to also start, giving psychological support to people. And we also didn't think we would ever have to give support for rent to people. And then you have a whistleblower who is going through unemployment or suspension or dismissal, and you are helping them with legal fees, but they don't have a roof over their head. They don't have money to buy food for their children. So then you also sit down and be like, okay, but how do we really support when they're hungry, right? Now, an element of monthly provisions now came in, but that was not part of our mandate from the beginning. But now it's one of those things that we have to think about when we think about holistic support. And our work really as PLAF is, in South Africa particularly, is grounded on the National Development Plan of 2030 and the National Anti-Corruption Strategy, and what these two instruments want to do actually when it comes to fighting corruption, when it comes to supporting whistleblowers. So the NDP 2030 advocates for a multifaceted approach to combating corruption through deterrence, prevention, and education. The National Development Plan's Objective 14 and the anti-corruption strategy prioritize prevention over reactive measures, emphasizing good governance, transparency, integrity, and accountability. So basically, they actually prioritize the creation of whistleblowers and the promotion of whistleblowing. Now, if national documents or instruments can promote this process, then why is support and protection so difficult, right? And I don't think it's intentional, even in the law, that our governments and our leaders, policymakers would promote something and then not give provisions of support. And that's where the Whistleblower Protection Week comes in, to discuss and see what we can share as good practice to our policymakers. Whistleblowing, stemming from the cultivation of ethical values, services as a crucial anti-corruption tool. And to encourage reporting of corruption, the National Anti-Corruption Strategy emphasizes safeguarding whistleblowers from harm and providing them with necessary support. As an educator, as a teacher, support begins before one blows the whistle. It also begins with what someone knows about blowing the whistle and how they blow the whistle. The retaliatory tactics, whether legal, can actually be prevented sometimes, or even be mitigated. The harm can be mitigated if an individual knows how to go about it the right way or the correct way. And some may say, but there is no right way or correct way. I'd argue and say, actually, there is. And we can come up with ways, toolkits of how to do it to prevent, I'd say, grievous harm. Harm will always be there, but I think the extent to which it really impacts and affects the individual and their family, I think some things can be put in place to prevent that kind of harm. So Whistleblower Protection Week is part of that support. It's part of looking in, part of sharing. And this year we're focusing on laws pertaining to whistleblowing. Not just the PDA, we're going to look at what Companies Act has to offer, what the Labor Relations Act has to offer, and what the NEMA has to offer when it comes to what we can get in terms of supporting whistleblowers and what they can get legally as well. And also is to answer the question, when we blow the whistle, is it for corrective measures and punitive measure, or is it just for correction? Because maybe we are trying to push for something when maybe a whistleblower only wanted to have something corrected, and then eventually they find themselves in court. And it was never for prosecutory reasons that they blew the whistle. And people need to know this before they do it, that you may actually end up in court. Do you have enough evidence? Can you really write a statement with the evidence that a prosecutory authority can use and prosecute? Or you are just blowing the whistle because you are told to report wrongdoing when you see it? Some of those questions that we need to also ask ourselves and answer, but also to look at what do we need to also say and do when we work with whistleblowers? What are those practical legal processes they need to be thinking of when now the NPA comes knocking on the door? And it's been 5 years, 7 years, that actually even looked at their affidavits and their statements. What does it mean? And the trauma that will also, now they have to relive probably as well. How do we support whistleblowers in those instances? So to actually welcome you this morning, I will call Inga from FNF for Freedom to do the welcome remarks. Thank you, Jim.
Thank you very much, Pusetso. So a warm welcome on behalf of the Naumann Foundation for Freedom. Here, like that? Can you see me now? Back? Yeah? Am I okay here? Yeah, we also have more audience outside here, so that's important. Thank you, Gemma. So a warm welcome on behalf of the Friedrich Naumann Foundation for Freedom. I'm Inge Herbert. I'm the Regional Director, Sub-Saharan Africa of FNF. There's two colleagues of mine here, Kwesi, who's managing, great to say, managing the relationship with PLAF and all the activities, and also Wayne Alexander from our Cape Town office. So whistleblowing should not be a death sentence. This was the headline that the South African newspaper ran with after the conviction of 6 men involved in the assassination of Babita Deokaran. The media's attention to this murder generated much needed public awareness of the immense risks and dangers faced by whistleblowers. Mrs. Deokaran's sacrifice is a stark reminder of the high stakes involved in standing up against corruption. Regrettably, Babita Deokaran is not alone in this perilous journey. There are countless unsung heroes and heroines who have paid the ultimate price for exposing corruption. For those fortunate enough to be alive in hiding awaits, constantly pursued by shadow agents in kleptocratic states and corrupt corporations. Their families are left devastated, forced to live in perpetual fear. As support rise up, whistleblowers and those who depend on them are often left with little means to survive and are made to eke out a meager living on the margins of society. With this in mind, it is quite evident that whistleblowing has become a de facto death sentence. So why do these individuals risk it all? Why place your life and the lives of loved ones on the line? These are the questions which impel contemplation. Fortunately, over the next few days, we shall have the privilege of hearing from courageous individuals, and some of them are with us here today, who have had to walk this perilous path and confront these questions head on. We celebrate and we express our deepest gratitude to these brave souls who have chosen to do what is right and what is good. Their efforts not only defend the principles of good governance, rule of law, and democracy, but also inspire us to continue this fight against corruption. And I'm actually very pleased that Gibbs has given their venue to this event today, because this is where you study, but this is also where people learn about governance in business. As the Friedrich Naumann Foundation, we are proud to support initiatives that uphold these values. Our commitment goes beyond policy and legislation. It is about humanizing the fight against corruption. We must always remember the faces and families who have sacrificed so much for the cause of freedom and good governance. We acknowledge that our intention is not to romanticize the harrowing experiences and ordeals of whistleblowers. Instead, we seek to emphasize the immense courage and sacrifice embedded in their decisions. Whistleblowers embody the spirit of justice and accountability, and their stories serve as a powerful reminder of the lengths some will go to ensure a better, more transparent society. In conclusion, we extend our congratulations to PLAF for their dedicated efforts in supporting and protecting whistleblowers. We also offer our heartfelt gratitude to our guests, organizations, and fellow citizens who have stood up against corruption. Your bravery inspires others to follow in your footsteps. During Whistleblower Protection Week, let us join hands in solidarity, ensuring that the sacrifices made by these heroes and heroines are never forgotten. Together we strive for an Africa where whistleblowers are protected, corruption is exposed, and justice prevails. Thank you.
Thank you very much, Inga. And with that, I will call now to the floor our panel to discuss the Department of Justice recommendations and any other, I guess, business that the moderator has on her booklet. So I'll call Ms. Zanele Mbuisa from PLAF. I think you're here, so just mic up. And there is Christopher Fisher from Helen Suzman Foundation, Mr. Ben Theron, Ben Theron from Whistleblower House, and Ms. Kavisha Pillay, our moderator from Corruption Watch.
Nice.
Over to you.
Hi, everybody. Good morning. My name is Kavisha Pillay. I am an activist and I've been working in the anti-corruption space for a long time. It is a pleasure to be with you today at the start of Whistleblower Week. And just to commend and congratulate PLAF and others who keep this advocacy alive. In the civil society space, you sometimes find that there's waves of engagement, and our advocacy can sometimes wane off when something comes off the national agenda. But these organizations, like Whistleblower House, Corruption Watch, the HSF, and so many others, the Active Citizens Movement, there's too many of them at the moment, but these organizations have kept the issue of whistleblowing top of mind. They keep sort of advocating for better reforms, and it doesn't require somebody to be fired or somebody to unfortunately lose their lives for these organizations to be active. So just to commend them, and you can see what this advocacy has brought us to. I remember speaking at the same event last year around this time and feeling quite a sense of despair. It was post the Zondo Commission. There was a lot of retaliation against whistleblowers. There still is now, but they felt like there was nothing that was happening within the political space to bring awareness to to bring awareness to the issue of whistleblowing and potentially help whistleblowers. A year later, I think I can fairly say that we heard from the Chief Justice last week, as well as the President at the National Anti-Corruption Advisory Council's National Dialogue, that whistleblowing is absolutely essential and instrumental in the fight against corruption. The Chief Justice was quite firm and at times quite hard with the lack of progress in terms of helping whistleblowers. But I think from a political perspective, we've seen some movement. I remember the times when we used to engage with different government departments, and they would say to us, the current PDA and the Witness Protection Act is sufficient. We don't need to make any changes. It's all there. We have the laws. And to see what's now put on the table in terms of the discussion document, I think is quite a step forward. And that's because of the work of these many civil society organizations. But it also came at a heavy price. It came at the price of Babita losing her life. It came at the price of Cynthia facing a detriment at her job. It came at the price of Martha Ngoyi being dragged to court every so often. It came at the price of many, many whistleblowers losing their lives and their livelihoods. So it has been a long time coming, but I do think that there is some movement and there are some steps. And now it's about how we activate this collectively and together to make sure that we're starting to bring in new pieces of legislation that are going to protect our whistleblowers in the country. So we are going to touch on a few discussion points today, or a few themes. I'd like us to talk about the issues around compensation and incentives. That's within the discussion document proposed by the Department of Justice. I'd like us to talk about the institutional architecture and where we should be housing complaints where whistleblowers have been victimized or faced retaliation. I'd like us to talk about interim solutions whilst we're waiting for new legislation to pass. And any other sort of gaps and loopholes that we have identified in this discussion document, as well as positive steps and things that we can be proud of. We will allow for some question and answer sessions from the audience today, as well as our participants online. So without further ado, what I will do is go to each of my panelists and perhaps in 5 minutes, just give us a brief overview of your organization's position on where you think the discussion document is lacking and what you think we should be supporting as civil society, but society as a whole. So I'll start with you, Ben.
The difficulty we have is that we're not sure the appetite that government has at the moment to, in actual fact, enable the whistleblower legislation, write it properly and enable it so that we can do that properly. If you look at the current status quo, you have ministers and people in very senior positions in government and the executive with a checkered past. The Zondo Commission have made pronouncements against them, but they continue holding this position. So it is interesting to hear the president talking about zero tolerance for corruption, but they're in fact supporting and putting those people in positions, head of subcommittees in parliament, and that's sad because it sets a wrong tone, it sends the wrong message out there, and we believe that the president should be setting the tone that says enough is enough. These people cannot have these positions. If you look in Gauteng, 2 people that were fingered, let me put it that way, now hold positions on a very important what is the word, company in the province. And that just says the ANC is not interested in fighting corruption. And we believe, we've seen it in the past, where just before the election, a number of tenders get sent out. And there's no other reason for the tenders other than milking the coffers. So no work is done. The tender gets put out, money gets spent, and then there's nothing to be shown for it. So we don't believe that the government is absolutely serious about corruption, and a portion and a pillar of that in National Anti-Corruption Advisory Council speaks about whistleblowing being very critical in that.
Mm.
We also hear about witness protection, which should be expanded to include whistleblowers. But if you look at the legislation covering witness protection, they actually treat the witness as a prisoner. And you get treated there, all your rights get taken away, you get isolated from your family, and you totally depend on the state. If you look at the quality of services that the state provides, you actually take 2 or 3 steps back. So nobody's interested in that.
Mm.
So we are very hesitant to support or to speak loudly about government being serious about whistleblowers in particular, and the legislation that should go about that. But let's for a moment assume that they are. To expect any progress before June, October next year, I think is a fool's dream. There's an election going on. People will make lots of noise, but very, very little work will in fact take place.
Mm.
That's where we are.
Okay, thanks, Ben. I will come back to you because I do want to talk about elections next year and whistleblowing and what voters should be looking out for in terms of making decisions when it comes to voting and what political parties should be advocating in relation to whistleblowing. Chris, any comments from the HSF on your view on the discussion document proposed by the DOJ? And yeah.
Sure. Well, look, I think HSF can echo the point you made in your intro, Kavisha, that it is a step forward.
Mm.
So when you look at many of the proposals, they expand the protection to whistleblowers. They take it outside of the narrow employer-employment relationship, which I think is progress, because that's not the only site of whistleblowing activity. It's also not the only site of harm to whistleblowers. So I think it does recognize and word this the spaces in which and the forms in which whistleblowing take. I guess I'm concerned, perhaps in similar to Ben's, is really the institutional heft that needs to come along to back up some of these great words that appear in the document. So we at HSF generally look at institutional strength and institutional weaknesses as quite it's sort of the story of South Africa's struggle at the moment. We have state institutions that are there in structure and in paper, but in terms of putting staff and commitment to really follow through with the institutional design of these institutions, we see government lacking. So when we see, for example, the expansion of witness protection to now cover whistleblowers, you think, well, what's the extra capacity going to have to look like on the ground in order to give them the protection that the whistleblowing that the witness protection process can offer? And then you have to consider Ben's comments that even the process that exists might not be the correct one. So the document, perhaps in those senses, it could serve as without really penetrating and asking whether these institutions can really deliver, might form as a distraction. We might think, well, we've got witness protection now, we can maybe take our foot off. No, that's not what happens. And I think there are other institutional gaps in the reforms as well. So the creation of a whistleblower fund, that's mentioned, but there's no detail.
Yeah.
There's no detail of how it's going to work, where the fund's going to go. Are there going to be terms of reference, procedures for claiming from the fund, corruption risks related to the fund, all these sorts of things that come up. So I think really, when we look at the bill, or we look at it's not a bill yet, we look at the proposed reforms, they're positive. Government is listening. But it's going to be in building the institutions that we're going to really see the success. And I suppose that's our concern.
Yeah, the proof will definitely be in the pudding. Sanele, from Plaf's perspective?
Yeah, so from Plaf's perspective, sorry, my voice is breaking because I'm recovering from a cold. So every now and then it might dip. I apologize for that. So from Plaf's perspective, we've always thought that definitely the PDA needed amendment. We know that it was a horrible document, which some might find quite controversial. I think it's one of the few legislations that actually has done away with even a notion of these, what do you call them, non-disclosures, right? To make, because before the previous one, before the amendment, people could be tied in these non-disclosures and therefore they couldn't whistleblow. Having said that, we agree that it needed amendment and expansion, and also crucial, it was one of the few legislations that I've actually looked at that did not immediately say this act should be read in connection with this act and with this act and this act. So it wasn't tying in other acts that are related to whistleblowing, like the Witness Protection Act. I see that it is important, the Witness Protection Act, but there are other crucial acts as well that needs to be tied in to the whistleblowing, because it's not one single thing. I'm also
You broke it.
yeah, I broke it. No. Did I break it really? Oh, okay. Right. So it's also one of the now I lost my train of thought. See, this is what happens. Okay, so whistleblowing and tying it with other legislation. And I'm also happy that one of the things that I mentioned is the compensation. I'm going to be a little bit difficult here because I think we need to have this conversation.
We
I
are going
think-
to. We can
yeah, I
have this
think-
conversation today.
We need to be very honest, right? And be very clear if we are going to protect people properly, right? Whistleblowers come in different forms, right? There is a perception that I see out there that people, and I understand why it is there because of what happened in South Africa with state capture. And I do think they are heroes, but there are various reasons why people whistleblow. And some of them is really to protect themselves. Some of them go to lawyers and the lawyers say, look, you were complicit in this. And as a result, you need to whistleblow. That's your only form of protection.
Yeah.
So now when we talk about compensation, these are things we need to look at. I'm neither saying they should be compensated or not, but one of the reasons, because everybody keeps mentioning the US statute, in the US, it went to various forms of amendments, primarily because of the various problems that they encountered with whistleblowers who were compromised and were getting compensation. And some people felt that morally that wasn't right because in addition to getting the compensation, they were also getting immunity for their whistleblowing. So those are the discussions that need to be had, whether we want the amendments to have a caveat or a qualification or whether we don't. And if we decide that we don't, how then do we deal with situations where someone may be opportunistic in that regard? I mean, another example I can give you, in the US, sometimes the whistleblowers wait a couple of months until the amount that they're going to report on is a bigger pot because the percentage that they're going to get would be higher.
Yeah.
So those are the factors that we need to look at. So that's what
So I just want to pick up on that because, and perhaps to move it away for the moment from the legal conversation that we've been having to one that's about the practicalities, the ethics around it, and touching on this issue about compensation versus incentivization. So I think we do need to sort of separate these two things. Compensation is, for example, when you are an employer and you get injured on the job, you can access the compensation fund, right? If you are a whistleblower, potentially, if you faced detrimental action as a result of your disclosure, you could potentially be entitled to compensation, which is what these proposed reforms are suggesting. Incentivization is where it gets a bit tricky, and there's been a lot more discussion, and I'm happy that there's this discussion in this debate that's starting, but the Chief Justice has said on numerous occasions now that we have to incentivize whistleblowing. We have to give people some type of reward for risking their lives and coming forward with these disclosures. What are the ethical considerations? Because are we then potentially creating a market for disclosures? Where you experience corruption and crime, there's also an ethical duty, there's also a legal duty to report these issues. Incentivization will obviously create an environment where more people may be willing to come forward with information, and we need that information in order to get the bad guys. But is this potentially going to be creating a market for disclosures, which then potentially will be abused? So, Sanile, just back to you on that.
Okay, so the way I look at it, I think we can actually extend, because what I've seen in the amendments, we just propose that there should be a percentage of compensation and then it ends there. I think on a practical basis, because now the PDA only states that you don't necessarily have, what you're disclosing about does not necessarily have to be true. You have to, at the time of disclosing, believe that it's true and not have bad intentions, right? So I think to cover or somewhat deal with the issue of compensation, maybe it should be said that maybe the whistleblower can get the percentage once the evidence that they've provided of the what they're whistleblowing about leads to a conviction. I say that for a reason, by the way. Our experience at Bluff in the last, I think, 4 years now, has been that some of the whistleblowers that we've protected and what they whistleblow about, when it came time to get to court and they had to be witnesses, it fell apart, right? So we need to make sure as well, because, and again, I'm saying this purely from a legal standpoint, because that's my engagement with Bluff. It's purely on the legal side. The rest is towards Bluff. While I understand that organizations like Bluff, Whistleblower House, and everybody else have to, in protection of the whistleblower, tell the public or publicize what the whistleblower is doing, what is happening. We don't really manage as well what the whistleblower is saying, right? We forget that whatever the utterances they make regarding what they're whistleblowing about, what they're saying, also can be used against them when they go and prosecute, right? When they go and testify, sorry. So when it comes then they get to the stand and it falls apart, right? So one of the things that we can say, actually, maybe that will also streamline things properly, is to say that upon successful prosecution and retrieval of the money, then they can get the percentage. I'm not saying that we should not pay whistleblowers. I think whistleblowers should be paid because I've seen the economic detriment that they go through. But I also think that people who whistleblow because they want to protect themselves and they were complicit in the crime, there has to be some certain level of accountability in there. You can't just say someone who knowingly participated in these corrupt or criminal activities, they then have to be rewarded with money and at the same time with immunity from the courts. So those are things that I think.
Ben, could I pose the same thing from Whistleblower House's perspective around incentivization? I think when we talk about incentives, we often refer to financial incentives. There may be non-financial incentives as well, but where does Whistleblower House stand on this question about whether or not whistleblowers should be incentivized and whether or not whistleblowers should be compensated if they face detrimental action?
I need to be honest, we haven't done the research yet. And we intend doing that research early in 2024, is to determine what should that look like. Is it worth it? Because quite rightly, what Zanelis talks about is people coming forward to protect themselves. There's a lot of research required to determine how will that change the landscape. And the difficulty is when you look at the amounts involved, is it the amount, and I think you touched on the topic, is it the amount that's been exposed or is it the net effect later on? What whistleblowers do, if you listen to them early enough, the amount could be as little as 20 million, the daybreak phone. It's at the time, a few years ago when the flag was raised, it was less than 20 million. She was fired. The corruption went on. It's beyond 200 million at the moment. So is it the 20 million where you start calculating, or is it 200 million that you calculate? And that is the problem. And if you look at South Africa, it's so endemic, you don't know where to draw the line.
Yeah. And there's obviously also situations where people would blow the whistle on an issue that has no financial or material amount to it. You know, so if you're blowing the whistle on an abuse of power in an office and there's no material amount to it, how do you then compensate a person? Well, not compensate, but what's the incentive for that person? So there's definitely a lot of research, and to an extent I can understand why, Chris, I think to your point, why the DOJ was a little bit hesitant because we do need to have extensive research on if we are creating a compensation fund, how does that work? And that's again also separate from this idea of incentives, should your disclosure, relate to a recovery of funds, etc. Just to move on, so Chris, let's talk about the institutional architecture, because I know that this was a part of the reforms that many people were quite concerned about. So there's, from what I understand, 3 proposals on the table, not just only the DOJ's proposal. The National Anti-Corruption Strategy proposes the establishment of a central whistleblowing agency, which will collect complaints. It would be able to deal with retaliation, it will be able to provide legal and psychosocial support, etc. The Zondo Commission recommendations say that the proposed procurement agency that is established should have a function in it that deals with the provision of whistleblowers and to assist those whistleblowers. And in those proposals, the Chief Justice speaks to potentially incentivizing and compensating whistleblowers, but it's quite limited to only whistleblowing in the procurement space. And then obviously there's the DOJ proposal that says that the Human Rights Commission should be expanded in order to receive these complaints around retaliation and to do those investigations. So there's different options on the table. Where's HSF? What is HSF's feeling about these different proposals, and specifically the DOJ's proposal about expanding the South African Human Rights Commission?
It's generally tricky when you make institutional criticisms, because the solution should also have some sort of institutional proposal. And in our submission to the DOJ, we were non-prescriptive. We tend to do that sort of thing. To say, look, we say we don't want to be too prescriptive up front. But when we talk about institutional capacity and creating it, I think at HSF is a general skepticism of creating brand new structures. I think there's a South African habit that we have, that we think we can structure our way out of problems, whereas a cultural change or behavioral change with what we already have is the most practical. There's also a lead time. So as important as a central procurement agency may be, and as effective as its inspectorate would be, where are we in putting that respect? Now we could say we are a decade away from something like that really coming. So what do we do in the interim? So the Human Rights Commission proposal seems to be promising, because there is an architecture there that is at least in place, and perhaps culturally it is minded to think about these issues in ways that are unique. We don't know what the Human Rights Commission's opinion is on this. I'm not too sure if they were consulted before the DOJ put the proposal forward. But a proposal that harnesses something that's already there, in our view, seems to be the smartest way to go, because that's going to shorten the lead time between here and institutional capacity. There's also some comments made by, I think it was actually then Deputy Public Protector, that the institutions were listed in the Act. So there's a list of, I think it's in section 10, I think the section 10 institutions. They're also existing structures that are destinations for protected disclosures. There was criticism, or there's comment made in the discussion document that there's really no real coordination plan between those institutions. So within our Chapter 9s and maybe there's structures there that we can harness and coordinate better. So I guess in short, there's a general skepticism about brand new structures, because they do have lead times. It's not to say that those are not, there's no in principle problem with those, it's more of a practical problem. So I guess then to really try and harness what we have is a smarter proposal from our point of view.
Great. Thanks, Chris. I mean, I guess, part of the hesitation as well is where even if we do capacitate existing structures, we know that they don't get the necessary resources. So even if we do go with the Human Rights Commission proposal, what would make me, for example, believe that this would be the good way to go is if that institution was then given the necessary resources and expertise and capabilities to be able to do this work, because we know that whistleblowers often face retaliation, they often face victimization, and the Human Rights Commission already has a huge workload, on their plate. So we would need to see those reforms in place before I think I would feel comfortable to go with that option. But just to open that to our other panelists, I mean, does your organizations have any particular views about the Human Rights Commission being the dedicated agency to receive these complaints, or proposed agency?
It was very confusing to me. Oh, not confusing, maybe one-sided. I think in suggesting the Human Rights Commission, I didn't see how. I thought maybe the focus was only on public funds, right? It wasn't really dealing with, well, what happens in the private sector, because there is whistleblowing there that's happening there as well. One of the things that we did see with the whistleblowers that eventually ended up at Zondo Commission, but then who blew the whistle, some of them actually did it in-house first, right? In the companies that they worked for. And the problem was that there was just, even though according to the current PDA, there is a dicta that says companies have to have a policy of whistleblowing and set up mechanisms in place to do that. And some of them did, but then they just deliberately, I say deliberately because they didn't oversee what was happening. So they would have a third party where an employee can whistleblow, but nothing would happen with that, right? And it didn't go anywhere. Then necessitated the whistleblowers to go to the next now reporting agent that they could go and whistleblow on to. Now, if you take in, say, the Human Rights Commission should be the place where it deals with everything that is whistleblower, does that include the private sector, right? Or not? Which is why our submissions were that there should be a whistleblower regulator. And this was specifically with regard to the private sector. So the whistleblower regulator would be sort of like the information regulator, right? You make the companies comply that they have to have a whistleblower policy, they have to have a whistleblower mechanism, there has to be standard times on reporting back, on investigations, and all of that. And if that doesn't happen, there has to be a hefty fine that accompanies that. So I think if it goes to the Human Rights Commission, a similar mechanism for if the Human Rights Commission deals with everything, both public and private, some similar things will have to be in place.
Yeah.
But then either way, there has to be some kind of regulatory oversight on private sector to force them to implement the policies, the whistleblower policies that they skim over and force them to act. Otherwise, there's no point in just doing it for public funds, because as we've seen in the Zondo Commission, the corruptee most of the time were the private sector.
Yeah, great, thanks. Again?
There's a process that takes place. Is number one, you have legislation, you have policies, etc. Then you create a structure, you populate the structure, and then the structure gets bastardized. We had great respect for public protectors in the past. The public protector office was totally racked out. So if you look at the structure that's required to manage whistleblowers, it need to be a solid structure. It need to be filled with people. The post should be filled with people of high integrity.
Yeah.
But invariably, on the second or third iteration in South Africa, that gets hijacked and we go sideways. And if you look at the example of the state security, remember this is now highly confidential information. You deal with people's lives, etc. And the moment there's secrecy and confidentiality, money laundering takes place. Money gets stolen, gets misallocated, misappropriated. And we don't have an answer for that. Because the moment you put something in the state's hands, and if you look at our track record of South Africa, we do not have a good one. Structures get totally taken over and corruption sets in. And if you deal with a whistleblower environment, you deal with people's lives.
Yeah.
And that's what scares us.
Yeah, I mean, those are definitely legitimate concerns. And apart from, sort of politicization of those spaces, I think if there's no politicization of those spaces, like I mentioned before, they get destabilized because they don't get the necessary resources and support. And I think a practical example that we can think of is after we pass the Political Party Funding Act, which is not the best, but it's still a progressive piece of legislation. The IEC established the Political Party Funding Unit. And this unit is meant to receive the disclosures of all political parties in the country. From what I understand, there's 500 political parties in the country. All of them are meant to be making these disclosures to this Political Party Funding Unit. And there's only 6 people who work in this unit. So this is some of the risks that we're going to face. Obviously, it having a Chapter 9 status will give it some type of independence in terms of budgets, in terms of who can be appointed. But again, there are some weaknesses, and we don't want the same thing to happen should the Human Rights Commission take on this role. Before I open up for questions, I just have one last question is around the interim measures. So it takes a very long time to pass legislation in this country. And even if we see the proposed reforms finding its way into a bill, as been mentioned, next year is an election year. So it's unlikely that we're going to see anything land up in Parliament, anytime, within the next year or so. So it's probably going to take us a long time. But in this time, whistleblowers will still face the issues that they have been facing for all of these years. What should we be putting in place, or what should we be advocating for that in this interim period that will at least provide some type of relief and support to whistleblowers?
Why are companies waiting for government to make legislation before they act? Whistleblowers come forward, and I'm not talking about the exceptions that you've raised. Whistleblowers come forward to expose corruption, and companies save money in that process. But everyone is waiting for government to say, may or may we not provide an incentive. Everyone's looking at government to say, should we wait for, they should change the legislation before we provide services and support to the whistleblowers. And I think it's a cop-out. Whistleblowers are saving this country, literally saving the country and companies on a day-by-day basis. But all they get in return is harassment, abuse, murder, and the list goes on. And companies have the power, they've got the financial muscle to in fact support whistleblowers. I'm not talking about organizations like us. It is actual fact supporting whistleblowers and continuing paying whistleblowers salaries, making sure they are safe, change the culture in the organization, etc. So there is something that can be done. And organizations such as BLSA, Business Leadership, Business Unity South Africa, those structures should start playing a role in changing that. But it's as if they like talking to government in fora and nothing happens there. They can step away from that fora and actually start implementing these things. So there is a solution. They're just not thinking that way.
Okay, Chris?
I think I can only echo some of that. Well, I find something that is quite astounding is this joblessness that follows being a whistleblower, particularly a good faith whistleblower. I know there's some that are perhaps complicit. So perhaps we can approach this issue with some nuance. But this idea that good faith whistleblowers have been struggling with unemployment, to me, I think that's a cultural aspect of this whistleblowing problem that could be fixed with some sort of interim advocacy problem, advocacy program. And I think what you'll do there is at least relieve some of the financial hardship, some of the structural hardship that these people and their families go through. That to me is something I think that can be done without legislation in the interim with certain collective efforts within the private sector. So perhaps that is something I think that we could do while waiting for these to concretize into law.
Sorry to put you on the spot, but I mean, are there any sort of practical proposals that you would be able to advise activists, civil society organizations that are sitting in the room? I know they're doing a lot anyway, but what are the lobbying points between now and getting new legislation on the table?
I mean, it's just related to this idea about joblessness. I think there could be we haven't actually put any forward in our submission or anything, and I can't say that HSF provides the support.
Mm.
But there could be something just nuts and bolts that could be done is to link up with whistleblowers and recruitment agencies just to make sure that they are being treated, and we monitor those relationships, monitor for data as well to see exactly how these employment searches work and what kinds of responses whistleblowers get from employers to somehow measure and predict and explain some of the rejections that might occur. Something like that that could be done practically in the interim.
Okay, great. Sanile?
So on a practical level, to an extent, I think we are somehow doing it with bluff in the sense that when it comes to the occupational detriment, we're there immediately with the legal assistance that is needed to defend the whistleblower or protect the whistleblower. The problem that we have, though, that we normally see, and I understand why it happens, because someone is facing this occupational detriment, and in that occupational detriment is in a form of being bullied, being threatened. And so people sometimes are frozen. It has a chilling effect. People are frozen into not acting. So a lot of times, by the time they end up coming to me, we've run out of serious time, right? So what I would say on a practical level, on a quick level, if you are whistleblowing and you're still working, you do need to contact organizations like us, like Bluff, because the sooner I get in there, the sooner I'm able to offer the protection that someone needs, right? And if we do that just on a practical level, if we manage to preserve your job, right? It's something. It's better than fighting from the outside, because once you're out of that job, that's where they want you, because they know you're not going to have money, you're not going to have resources, and you probably have run out of time, right? So on a practical, just first step basis, really, if you're whistleblowing and you're at work and you're suffering occupational detriment, you absolutely need to contact organizations like us, like Bluff, and we'll try and get in there as soon as possible.
Yeah, no, that's great. And I mean, hopefully, all these are just interim proposals, and I wish that I wish we didn't have to have this conversation, but I think that we do need to come up with a sort of concrete list of advocacy points and lobbying points amongst us as activists in civil society organizations. And as Ben said, you don't have to wait for government. We do have certain means and resources and capacities amongst us to be able to, assist during this transition period, in the hope that we will get a progressive piece of legislation that will alleviate some of this pain and difficulties that whistleblowers face. Could I take a round of questions? Gemma, you let me know if there's anybody online as well, but any questions or comments from anyone? Okay, 1, 2. Okay, let's start.
Thank you. Okay, my name is Baring Mugwena. You asked what can be done practically to sort of assist with the joblessness of whistleblowers. I think practically, maybe for government to demonstrate that it's serious about fighting corruption, if there can be a measure to say, if a whistleblower loses their job, there's a database of whistleblowers, then contracts or fixed term jobs that becomes available on the part of government, before government can recruit from the general, public, maybe it should consider that database of whistleblowers, because amongst other things, what as a whistleblower you're likely to face is the whole issue of having to fight your case at a labor court alone and without a job. But if maybe at least there's a way of earning a living whilst you're fighting that case, maybe that can encourage people to come forth with irregularities or criminal activities that happens in government or even in private sector.
Yeah, thank you. There's a hand at the back.
I think first thing I've got to say is that we cannot afford not to have whistleblowers. So when we start talking about costs, it's cost? What's the cost of not having whistleblowers is what we should be talking about. If we look at the cost of not having whistleblowers, for example, with regards to load shedding caused by people sitting on the boards of ESCOM, we know what it's done to our South Africa. Just load shedding. When we look at a case like Babit, 1 billion rand that was stolen from us has caused the collapse at Tembisa Hospital and continues to cause a collapse in health systems. So even before we start talking about compensation or debate, we need to debate the fact of what is the cost of not having whistleblowers. Currently, we have this thing of negotiating with people in terms of plea bargains. Okay, so you have somebody that's committed a crime, but then you plea bargain. That cost is already calculated. So we'll give you a lesser sentence if you tell us some information. Myself, having suffered with loss of medical, loss of income, I don't think as a whistleblower, many whistleblowers want to make a profit out of the process. What they're really looking for is a compensation on 3 levels. One, what has it cost me to get to this point in terms of taking out money, for instance, to drive from my home to police station to lay a case, to consult with lawyers? What does it cost to get this process going? The second one was, what is the compensation for my future? So remember, a lot of people get caught in a crossfire. My family gets caught in a crossfire because now I'm losing my income and impacting their ability to contribute more positively in future. And then I know something like the false claim in the US, which encourage people to come forward as whistleblowers. On average, put out of $1.5 million US. How that, you know, how that figure comes about is based on the fact of what's the claim that has recovered from the fraudulent thing. So it's still, you know, a percentage of recovery. But as I say, most whistleblowers are not doing it because they want to make a profit out of the system. They certainly want to make recover what has been lost and what helps them to go forward. So the last thing I just want to mention is that mental health is a major issue, and it's a continued thing that people, when you do whistleblowing. So even if people are not paid private professionals, certainly there should be a fund to help people to deal with the trauma. It's an absolute trauma being a whistleblower.
Thank you. Any other hands? No comments online?
Good morning. My name is Michael. Perhaps just a question regarding the structure. The panelists were talking about the creation of a structure. So I would like to know more, what would be the nature of the structure? Would it replace the mandates of other institutions or work in tandem with them? If perhaps they can explain a little bit further about this structure that everyone has been talking about that is being envisaged. Thank you.
Thanks, Michael. We'll respond to that. Gemma, any questions online?
We have a comment online from Local Cast who said that the clear irony for him to witness Chief Justice Sondo swearing members of Cabinet who were implicated in state capture, it must have been a difficult constitutional exercise to undertake.
Definitely. Thank you for these comments and suggestions. I think that that's been useful. Michael, just to answer your question in terms of the structure, and I'll go to my panelists as well. From what the proposal on the table is that the Human Rights Commission be expanded in order to receive complaints where a whistleblower has been victimized or they face retaliation. So you could blow the whistle, for example, to your employer and say your employer does not respond to that, because there's also penalties for non-responsiveness to a disclosure. So if your employer does not respond, or you face victimization as a result of that disclosure, you could now go to the Human Rights Commission. This is the proposal. They would then conduct an investigation, and that will then lead to potential consequences, which could, if the sort of party is found to be guilty, could include jail time, or a penalty and a fine. So those are the sort of proposed interventions that's been put on the table by Justice. But I just want to go to my panelists to see if there's anything additional to that.
There's a matrix required, and it does not help you put in a solution that's impractical. So they speak about the Human Rights Commission, but to get this solution for whistleblowers out properly, you need a network of service providers throughout the country. You can't have it centralized. They make reference to the legal aid the legal aid board. There are limitations and qualifications, criteria that you need to meet. And the difficulty you have is not everybody will meet that. So how do you overcome that? So it's a good discussion document, but there's a lot of detail that need to be fleshed out, understood. And it's not a bureaucrat a bureaucrat don't understand real life. They sit in an office and they think they understand the problem and they have a solution, and they have a solution where the problem is not. So it need to be practical solutions for whistleblowers that meet whistleblower requirements. And then the last thing is they should not have something that people purely do for compliance sake. So today you have whistleblower hotlines like crazy, because that's a requirement. So a legislative requirement is that you do what's required in terms of that, but what you do with that information is actual fact to go back and to bully and to make the whistleblower suffer. So there's a whole process. There's a mind shift that need to happen. There's a culture change which must happen. So it is a radical change that we need to experience and work towards experiencing over the next 5 to 7 years, even before the legislation is finalized, and then the hard work begins.
Any other comments on that?
No, I think you've captured everything, really. Whatever the legislation gets to be amended to, I still emphasize that it has to not only be focused on public funds or public institutions, it has to include private institutions. It has to have set deadlines on investigations, on communication with the whistleblower and taking things forward, right? And there have to be heavy penalties for not complying.
Yeah.
I guess one insight I found quite valuable in the question was the idea of having or recognizing that even if we do capacitate the Human Rights Commission, it will exist an ecosystem of other receptacles for whistleblowing. Maybe not by design, maybe just by practice. Certain people feel more comfortable going to public protector or something like that. And there does need to be some sort of an understanding of how the ecosystem works from that central point. So I think that's an important contribution to a future institutional design of the whistleblowing apparatus.
You know what I found interesting, Cynthia, I'll come to you in a second. What I found interesting in the discussion document was related to this issue about if I receive a disclosure and I don't act on it, you'd potentially face some type of fine or penalty. And that was interesting in the context of civil society organizations that have been established to assist whistleblowers. You obviously receive a number of complaints and disclosures that you wouldn't have the resources or the capacity to be able to properly help that whistleblower get the support or the assistance that they need. And some of the issues may include, the whistleblower just doesn't have the information in order for you to investigate or for you to act upon and so on. And that potentially poses a dilemma to those working in civil society who are receiving these complaints, because you would potentially, to an extent, be held liable for not being able to provide the adequate support. Now, on the one hand, I think that it's great, because I think whistleblowers need to be able to get access to support, no matter who they go to. On the other hand, it could be seen as quite punitive, especially on those who aren't able to practically, legally give that type of support in the form of investigations, etc. So there's a lot of things that we need to tease out here to make sure that Especially also in the context where whistleblowers potentially trust civil society organizations more than going to, for example, law enforcement agencies or going to government departments or their employer's hotline. You know, we need to be able to make sure that you're still creating a space where you're encouraging people to come forward with information, but those people that are trying to provide assistance and support are not going to be, you know, hit with any punitive measures as a result of not being able to help a person to the T. And from experience, you'd find that, you know, you'd be able to take a person so far, but because they're feeling disgruntled, there's nowhere else to go. They would then feel dissatisfied and go to the Human Rights Commission and say, oh, Corruption Watch didn't help us. You need to go and investigate them. So it's good. This ecosystem that it's going to create is still quite difficult, and we definitely need to work through that. Cynthia?
Thank you very much, Kavisha. I just wanted to add to the conversation around the compensation and reparations for whistleblowers. The Protected Disclosures Act actually has sections that talks about claims, damages claims, and I don't think that has been investigated or acted upon for whistleblowers enough. Maybe it's gone to a certain point and not enough. And that needs to be fleshed out a bit more, because the PDA does cover that. One can claim those damages suffered. And so it doesn't have to go, so there's the route of having the whistleblower fund on the one hand, because not everyone can go and do a damages claim. But for those who can then claim damages, I think that route must be followed quite effectively. And our legal fraternity needs to explore that more. Thank you.
Yeah, definitely. And that's a practical interim proposal.
Well, you're all right. It has actually, there are a number of cases that have gone to the High Court that were brought by whistleblowers, and they did get compensated. Yeah, I agree with you. That has to happen. There's always that option, by the way, in South African law. Even if the PDA didn't have it, on a common law basis, you would have that route that if you have been damaged in any particular way, you can take that person to court, right? So the problem, I think, is because legal services do cost a lot of money, and that in itself can be prohibitive. But there are legal firms who can take your matter on a contingency. So there's avenues. It's not that, like I said, PDA is not completely rubbish. It isn't, but it does need to be improved for sure.
Yeah, definitely. Anything else, Corbin?
Thanks. Good morning, all. Thanks, Kavisha, and thanks to the panel. You know, my name is Kugan Pillay, an independent consultant, but I've also made a submission as part of the active citizen movement to the Zondo Commission, and then also served in the National Anti-Corruption Strategy, which led to finally the NACAC being established. I think this is not a normal policy discussion, not a normal improvement discussion. It's a life and death issue. And when we hear from Ben Taron talking about, you know, how serious the situation is with whistleblowers, when you hear from Zanella that these things can be done, the question I must ask, I mean, I'm sure many of you, some of you would have been at the NACAC meeting last week, the dialogue. So while the president was speaking, witnesses were gunned down outside Randburg Magistrate Court, just as the woman was about to give testimony against the 4 police officers that were involved. But they took her out and her husband. And then there was much criticism about the president talking, making all these promises, but not seeing any urgency on action. And I mean, Kavisha mentioned earlier that this legislation takes long. I think what we must unpack is, what is long? I sat on an international meeting last year where some US colleagues said they approached Congress about whistleblowing legislation. And the people said to her, they dismissed it, don't worry, it's gonna take about 10 years. She proved them wrong, and she got it done within 6 months, obviously at great expense to these activists who do not have the resources. So I think with us, because it's a life and death issue, you've also seen in the last 48 hours, the impact on GBV, a young student, woman student, taken, stabbed by a boyfriend, a colleague being gutted by what you call by another person. So I think whistleblowing lends application to lots of fundamental rights in the Constitution. And at the center of it is Ubuntu. It's about respect for each other. And then also is Batopela, service delivery. And I think, as Ben said, we can't ignore the contribution they have made for our young democracy. Zondo mentioned this last week as well. And he's so passionate about this. He's just shocked that we're not moving fast enough. So I think maybe coming out of this, maybe some guidance from Kavisha, who sits on the NACAC, we can put a team together to support NACAC. We can marshal the resources, because this is life and death, and it's going to escalate before the election. And yes, the election is happening, but the election doesn't have to be a distraction. Just to give you an example, I'm also working with Justice Richard Goldstone on some international anti-corruption projects, interventions, which we've shared with NACAC, and we intend making submission. And part of that is the lobbying for these international institutions. Peter Hain in the UK has put this on the election manifesto. The UK goes to election next year. Can you believe it? The Labour Party has grabbed onto this and they put it as part of the election manifesto. So likewise with us, we mustn't just leave it in NACAC hands. We mustn't just leave it in the president's hands or the ANC's hands. We need to canvass the other parties to say, this is life and death. This is our constitution. This is what state capture has done. And we need to give more support to Zondo, because Zondo seems to be the lonely voice championing anti-corruption, championing whistleblowers, and the poor whistleblowers get marginalized. We've seen Babita 2 years ago being taken out. Martha is still going on. Cynthia has also paid the price. So I think for me, whistleblowers are urgent, critical, but it also lends a bigger implication for our democracy and saving our country. Thank you.
Thanks, Kuben. Kuben took my closing remarks, so I think we can go home now. I'm joking. I'm joking.
Good morning. Just a quick one. My name is Ali Gule. I'm here as an activist, but I also work for OUTA. This is a personal opinion, not for the organization I work for. I think we've got a good opportunity to take it into our hands, not to rely on government and politicians about encouraging whistleblowers to come forward with the information. There's a reason why whistleblowers trust civil societies more than government. And I think we must take advantage of that because for the speakers have already indicated, it's not an easy task to embark on to challenge the status quo. I've heard that we cannot rely on those who create a problem to come with a solution. Sometimes the information you want to declare implicates your own leaders. Let me declare, if that won't make me unpopular, that in my previous life, I'm a former ward councillor of ANC. Please, I'm no longer belonging to it now. In the East Rand, it's called Ekurhuleni now. You must have realized all council vehicles in Ekurhuleni upload big stickers at the back where you can report corruption. Has anyone bothered to check how many people are reporting corruption on those numbers? Probably nothing. Because when I was a councillor, you'll talk to an official don't know who's on the other side of the line. If you report that Mr. Theron is doing 1, 2, 3, you might be inviting uninvited guests for yourself. You might be putting your life in danger. Let us look at PDA and those anonymous 0800 numbers if civil society cannot be in charge of that. In closing, I'll give you an example. Only MEC of Health in Gauteng did not act upon the CFO to whom Papita reported the case of Tembisa Hospital. It's in the public domain. She said she's waiting for SIU report before she can act. Sorry, I almost used the wrong language. What's that?
Yeah.
Why must an MEC wait for SIU report as if SIU now is part of government, of her department? As if that was not bad enough, the people who were implicated, companies that were implicated, Tembisa Hospital, Saka, some of them even today are still doing business with. So there is no political will. There cannot be two ways about that. So it's up to us now to consolidate togetherness and work together more than before to take the fight to the government. I think whistleblowers, potential whistleblowers under the circumstances now, the environment is not conducive enough for them to stand up and be counted. We are missing an opportunity to exert pressure and to promote and protect whistleblowers now more than ever. Thank you.
Thanks, Andy. Colleagues, unfortunately, we are running out of time. But just to thank Ali and Kugan for those comments. And obviously next year is an election year. And one of the things that we should be doing is making sure that, I mean, there's going to be, we're going into a silly season. So everybody is going to have some type of proposal or solution to deal with corruption in this country. And malfeasance. But I think one of the things that we have to do is make sure that whistleblowing and being able to support whistleblowers becomes an election issue. It has to be, because this is how we start to create political will. You know, if this is what the people want, and this is obviously no disrespect to Plaf or any of our colleagues, but we need to take these conversations about whistleblowing outside the walls of GIBS. And we need to be having these conversations, and it's not just the responsibility of Plaf, it's all the activists and civil society organizations and anybody that's supporting whistleblowers. We need to be having these conversations in communities with people in, you know, corporate spaces, with CEOs, with employees, because this has to become an issue if we are going to force political will. And I'm hoping that when we meet again next year for Whistleblower Week, we can say that our advocacy made in the run-up to elections, that we did see some solid commitments from political parties to put legislation on the table that will be able to improve the environment. You know, Kugan was talking about GBV. In about 2019, we saw in record time, there was, I think in 18 months, they passed 3 GBV bills that were pretty progressive bills. So it can be done. You know, if you put enough pressure, there was a lot of gender justice organizations who were marching, who were, you know, demanding some type of support, you know, put a lot of political pressure on the president and the governing party. And they got those bills through because everybody, all political parties supported this idea that there should be no gender-based violence in the country. Now, we need to get all of our political parties to support the idea that whistleblowers shouldn't be retaliated against. It's a bit more of a tricky situation because it doesn't always benefit those in power, but we as the public and we as the people need to make this an issue. So on that note, thank you so much to our panelists for participating. We're hoping that when we see some draft bills on the table, we can come back and have this conversation to see if they've taken our comments and suggestions and submissions forward. I really do hope that they do. And thank you to all of you for continuously supporting the work of Plaf and other whistleblowing organizations. And this is not, I mean, this is a journey that we're on. We know that there's going to be no silver bullets. We know that this fight is not going to be won tomorrow, but I think we've come a long way. We are seeing some gains and we just need to keep lobbying for this change, and hopefully within the next few months, or hopefully not years, but within the next few months, we can start to see some real progressive amendments and support given to whistleblowers. So thank you everybody and enjoy the rest of the session.
Right. Thank you very much. I think now we can take maybe like a 15 minutes just to grab coffee. Hear some solidarity messages, and we will hear from Just Voices, who are going to present a guidebook that we've been working on. And we've spoken about the damages in the PDA. They'll probably highlight that as well, and some of the other legal frameworks that are available to explore for whistleblowers moving forward. So 10 minutes, and then we come back. Thank you. movement, ACM, Action Citizens Movement. Yes, I had to remember it, so I'll welcome you to give yours. And then from there, we'll have a presentation from Just Voices. So I will thereafter welcome Chantel and Zunaid for that.
Thank you so much. And thank you so much for, I think, giving Defend Our Democracy the opportunity. So Cynthia Stimple is one of our national committee members and reminded me today that 2 years ago, 1 year ago, we held the Conference for Democratic Renewal and Change. And this was a conference of a number of civil society organizations. And we developed some sort of a program of action that tried to indicate to us where civil society needed to be concentrating its efforts in the last, in this next period. And one of those specific areas was around whistleblowing and the need to bring together organizations to work collectively on this issue, to begin giving thinking to new whistleblower legislation, and to also offer a kind of network of support for whistleblowers. And from what Cynthia and at Whistleblower House, at PLAF, Corruption Watch, OUTA, and a number of other organizations, Active Citizens Movement, it's really what you all have been doing. And we can safely say that this area of work has really been pulled together and has, in a way, this collaborative effort has taken it a step forward that I don't think we've seen before in civil society. So you may not feel like you are making a difference because we watch the news and we see that 2 people are killed outside the Randburg court as they're going to testify and be witnesses. We look at Martha and Goy every day and we see that consistent persecution that continues despite the state claiming that we are now beyond the state capture period. We still see the family of Babita Deokaran left in shambles and the family of Lieutenant Colonel Franz Matipa similarly struggling after their father and husband had been killed. But I think that if it weren't for organizations like this here, there would be many more cases. There would be many more that are afraid to come out. And the stories of those who did take the stand, and despite the treatment they received, despite the persecution through your organizations here, you have highlighted their voices, and particularly their call that they would not, if they had the offer to do all of this again, they would not back down. They would still do what they're doing. And I think that's particularly important as we go forward, especially into this election period. So as we go into this election period in 2024, we will begin potentially seeing political parties who don't have enough money for their campaign wanting to divert state money for their campaigns. We will see public servants potentially being put under pressure to divert funding meant for service delivery or some sort of community project, to divert it into political party coffers for their own purposes. And I think the organizations here, together with others, can play an important role in monitoring that, in calling out political parties when this is done, but also encouraging public servants to be wary of what may be coming in the next year and offering a supporting hand to them. Lastly, we shouldn't back down on the pressure that we need to be putting for the Zondo Commission recommendations to be implemented, especially that about whistleblowers and protection of whistleblowers. So I'd like to propose an idea to this Whisper network that is here, and that's into next year. Consider potentially hosting 5-6 political parties on a platform and asking them what are they practically putting forward as part of their election manifestos around whistleblower protection. They can all say, yes, we support whistleblower protection, but what does that mean practically to them, and how are they going to be able to demonstrate that support, whether they are in power, whether they are not in power, and just perhaps in portfolio committees, how are they going to actively demonstrate that, and how do we then collectively hold them accountable to those commitments? So once again, well done to this network. Continue the work that you are doing, and I think you've really set the benchmark for civil society organizations in all sectors to do the same. Thank you.
All right, thank you very much. I always say that what happens in, I'm interested in what happens in South Africa when it comes to whistleblower support, because we can always, export it to other Southern African countries. I'm from Botswana and I coordinate Southern Africa activities for PLAF. So what works here will definitely work in Botswana, in Namibia, Mozambique. So when I push for things, especially what we're doing with WISPA and the support value chain that we're trying to establish, it's really from a selfish place, because I want it so much to work, because if it works here, then we can take it elsewhere and help fight corruption in the region. ACM representative to give their message. Are they here? I mean, we received it on email. I don't know if maybe we're supposed to read it ourselves or if someone was going to read it. Or anyone from ACM. Well, then if Kugan does not know the question and what we're doing, I think we shall leave it and we will share the message that was sent by email. No, we're giving solidarity messages, and ACM had sent their message to us by email, and we thought that someone was going to read it to the people. But I think we can continue with the program. But we did receive it, and we thank you, ACM, for sending that message. As PLAF, and then I think with WISPA as well, we've been wondering, what are we missing? What are we missing when it comes to whistleblower protection and whistleblower support? And one of the main things that we realized that we wish we could do more of is actually help people understand what a legal process whistleblowing is and what it entails and what it takes. Occupational detriment, once you suffer it, you're already thrown into a legal process. And it is trying to have people understand that process that we wish, from an educational perspective, because part of our work is to educate and train and equip people with tools on how to survive. So the moment you're thrown in that tumble dryer, how do you survive? And the moment you realize you need to blow the whistle, how do you survive? So we came up with an idea to work on a guidebook, a whistleblowing guidebook that Just Voices actually did the research for us. And this guidebook, we hope it gives you, not just you, but potential whistleblowers, other organizations, a roadmap, a guide on what to do, how to engage with whistleblowers. We also have a first responders guide, like in conjunction with that, how do you engage with whistleblowers to know of the journey ahead? So this guidebook looks at an analysis of pertinent laws, court interpretations, and methods of claiming damages. For example, Cynthia and Zanele were speaking to the fact that the PDA does provide for claiming for damages. So we're hoping that this guide can elaborate more on that. It also looks at, or attempts to look at, practical aspects of representing whistleblowers from the first day of consultation to trial, but also in some instances, settlement negotiations. So we're hoping that this guide really is a gift to whistleblowers who at times may need closure in understanding what exactly happened to them and why it happened, and where we got it wrong, why we got it wrong, and where we need to stretch the law a little bit to actually do it. I know most of the cases are prescribed, and we always think there's nothing we can do legally. But is there something that can be done even beyond that, right? So we're hoping that this guidebook will answer some of those questions. And if we have not answered them enough, please do give us some feedback and we can go digging some more so that those who read the guidebook moving forward can be more well-informed than we were last year and than we are today. All right, so with that, I will call Chantel and Zunaid from Just Voices to present some of the highlights from the guidebook, which will be published on the 9th of December, which is the International Anti-Corruption Day. So just to commemorate that day, we'll have that guidebook publicly available online. Thank you very much. Welcome, Chantel and Zunaid.
We see a lot of research and advocacy around what needs to be done to improve the situation of whistleblowers, but there's not much at the moment about what have we got on the statute books, what have we got in practice. So I see some lawyers here, but I also see whistleblowers and civil society. So if you don't know, in South Africa, we either work with what's on the statute books, so we've got like the Protected Disclosures Act, or we've got what judgments have said over the years. It becomes precedent and we can follow it. And basically we just use it to interpret the legislation. So who is this guidebook for? So it's to prepare potential whistleblowers. And one of the issues that often comes up, and I'm looking at Cynthia, who often poses this question of when does a whistleblower approach the lawyer? Now, ideally, from our perspective, we'd love it if they came before they blow the whistle. But unfortunately, that's not always the case because whistleblowers don't even know that they're whistleblowers. They don't even know what to do. They're just thinking they're doing their job. So that's the first one. Then it's to prepare whistleblowers who are facing occupational detriments. Okay, and occupational detriments is pretty much anything negative happening in the workplace. So that's suspension, demotion, transfer, and of course, the most popular one is dismissal. And then, of course, legal practitioners, because many practitioners I'm looking at, Bareng, he often works in the with public servants, and he's often faced with these questions. And then lastly, for civil society. So we hope that civil society who work daily with whistleblowers can give them this guidebook and say, look, I'm not a lawyer, but perhaps take some reference from this. Gemma, can you just turn to the next slide, please? Okay. So where does this guidebook come from? So in Pluff's experience and what I've noticed in attending these sessions is that whistleblowers feel completely abandoned by the justice system. They were told that they are protected. They're encouraged, in fact, by the government, by the state to blow the whistle. And then once they do, their lives are turned upside down and they don't know where to go. That is the biggest problem that's faced by whistleblowers. Then there's this David versus Goliath that we face, right? So employers, chances are they're in the public sector, they've got very deep pockets. They don't really have to account how money was spent on legal expenses. It becomes a fight over which budget does it have to come from. But you as the whistleblower, you're an individual, you've maybe got your salary, or you've been fired and you're waiting and you've just got your pension to rely on. So it's a very unequal playing field. And we hope that with this guidebook, you're at least capacitated to at least try and equal the playing field. And then, of course, the legal landscape is convoluted and overwhelming. And even as attorneys, when Zunaid and I were working on this, we even found that ourselves. There have been, especially the 2017 amendments to the Protected Disclosures Act, tried to put in more protections, but it made it very difficult to understand, but where do I go now? What is my forum? So even though the protections are there, it's confusing, it's overwhelming. Not all legal practitioners work with the PDA on a daily basis. So that's the situation we face. So in the guidebook, we focused on the Protected Disclosures Act, just the PDA, the Labour Relations Act, the Companies Act, and the National Environmental Management Act. There are so many other pieces of legislation which deal with whistleblowing or deal with an obligation to blow the whistle, like, for example, the prevention on the PRECA, there we go, on PRECA. So we've just dealt with those four because they really give the most protection. So Gemma, can you turn this side? Okay, so what have we defined whistleblowing as? We've used Plough's definition, which is the person who discloses information regarding actions that are unlawful, illicit, or against public interest that they have witnessed, especially in the context of their work. Okay, Gemma, can you, next slide. Okay, so just to start off with is, if you're deciding to blow the whistle or your civil society working with whistleblowers, here are some general tips before you blow the whistle. Right, so when you make your disclosure, you've now decided, and this is again also a minefield of who do I disclose to? And at the end of the day, it's going to depend on what you're disclosing and what institution you're possibly working for or that you saw the wrongdoing. But when you blow the whistle, say that you're doing it in terms of the PDA, say that you're going to, that you fear facing occupational detriment, and that you try and encourage this institution to basically call this out as a protected disclosure. Because if you have to take this further down into court, it could be, the court might be a little bit more favorable in your line if they say, well, you know, the Public Service Commission has already called this a protected disclosure. Why am I, as a sitting judge, going to find differently? So that's the first one. Then the second is no rumors, conjecture, or notorious information. So this came out of a case of the Communication Workers Union versus MTN. In this case, the employee blasted off an email to management, the CEO, global CEO, that he believes that tenders are being given to a specific company. And the only reason why he said this is because all of their tenders relating to security were given to this company. When it went to court, he tried to get an interdict against his disciplinary hearing. On the first leg of that interdict, he was successful. But when he went back to court, the court now needed to do a more thorough introspection and said, actually, this is just your own opinion. This is not based on any fact. So that's very important because we see a lot of whistleblowers that are running with information that they've heard from colleagues, that they've heard in the corridors, or that have been in carte blanche. And then they say, well, now they're protected. And that's the thing about notorious information. So if I'm working at ESCOM, I can't go and say, now, you know, Brian Molefe, Anush Singh, the whole tribe was involved in corruption. So what? Everyone knows that. The fact is now they know it. Management is going to deal with it. Also remember that as a whistleblower, you cannot demand the outcome of that investigation to know what happened. You have a right to know that there's an investigation, that something's being done, but you can't get the report to know what's happening. And that's, we see that when we engage with the SIU, that's also something that they struggle with, is that whistleblowers continuously go back to the officers saying, listen, what's happening? And they obviously can't, because this is an investigation, there's confidential information. And in doing that, whistleblowers actually expose themselves, because eventually the perpetrator's like, oh, but he's always there at that office. It must be him. And remember, it's not so difficult to figure out who blew the whistle, right? There's only so many people on an email, so many people in a meeting. So there's got to be some sort of caution around blowing the whistle. And then there's the requirements is that there must be reasonable belief. So this goes to the issue of, it doesn't mean that you had to be there witnessing it, right? You don't have to, it can be on hearsay, but there must be a reasonable belief that there was some or other wrongdoing. I sat in on a hearing. I heard that they weren't following the procurement procedures, something like that. And that will qualify as reasonable belief. But remember, you as the whistleblower are going to have to prove that in whatever forum you're in. And then when it comes to blowing the whistle to the employer, again with the Communication Workers Union against MTN, the court also said to them, you didn't follow the procedure set by MTN in whistleblowing. MTN had a specific whistleblowing hotline, a fraud hotline. You were supposed to do that. You weren't supposed to bash off an email. So that's important with that procedure because it's specifically outlined in the law. And then when you disclose to social media and media, which we see a lot of whistleblowers doing because they're completely discouraged by the institutions listed in the PDA, there's a higher threshold. So when you go to court or you go to the CCMA and you say, I've been fired because I'm a whistleblower, you have to be able to show, okay, I blew the whistle to my employer. He did nothing. I went as far as following up with him and he still did nothing. And that's why I went to the media. This threshold is not so high if you're blowing the whistle in terms of the environment. Okay, so in terms which Zunaid is going to touch on the National Environmental Management Act, it's a lower threshold. But for everything else, that threshold is there. And if you don't comply with it, the court might not find in your favor. And then with section 6, 7, 8, and 9, so those are the employer and your institutions such as the public protector, all those publicly listed institutions that you can blow the whistle to, you also have to blow in good faith. Okay, and this is where the issue of skin in the game comes in. So some examples of bad faith that we've seen being decided by the courts are where, for example, in employees now claiming that they're being dismissed, that they were dismissed because they're being a whistleblower, is one case where a woman said, no, they didn't follow the correct procedure when appointing this person. She doesn't have the right qualifications. And the court said, but you were part of that meeting where that decision was made. So you coming here with dirty hands. So bear that in mind. It's not always so clean cut. But bear that in mind because you will have to answer for it somehow. So if you're going to claim duress, fraud, you didn't know what was going on, you just need to be equipped. Right, Gemma, can you just turn to the next slide? Now, who does the Protected Disclosures Act apply to? So it only applies to employees and workers. So that's independent contractors or agents. And this has obviously been a big criticism of the PDA, is it doesn't disclose to people from the public coming to blow the whistle. Right, Gemma, can you? Right. Okay, so if you're now looking at, I'm an employee, I've been fired, what do I do? Now, what's been banged on for the last 30 years is I go to the CCMA because that is the best, most cost-efficient process, right? You don't have to go with a lawyer, even though Bareng loves going there because he can write fees. But you don't have to go with a lawyer. You can go there by yourself. So this comes from our constitution. Our constitution guarantees the right to fair labor practices. So everyone has the right not to be unfairly dismissed. Everyone has the right not to be subjected to unfair labor practices and occupational detriment, which I said earlier is all those negative things happening in the workplace because you're a whistleblower. That can also be referred. And then we've got, sorry, Gemma, and then we've also got that if you haven't been dismissed, but you've resigned because employment became intolerable, then you can also refer a constructive dismissal to the CCMA. And then we've got, again, with the unfair labor practices. Okay, Gemma, can you? Right, now what's important is that when you approach whatever forum you're approaching, is that you make it clear that there's a connection between what you blew the whistle on and the occupational detriment. Now, it's very easy if, say, for example, you blew the whistle on tender irregularity and your charge sheet says you are hereby charged with insubordination in that you failed to sign the tender documents, right? That's clear. I can see the connection. However, what normally happens is they'll whip something out that you did when you first started that you didn't know anything about. And they say, but you signed that invoice. And lo and behold, the invoice is for a whopping 5,000 Rand, but now you are standing to lose your job here. So when you are faced with that type of scenario, when the nexus isn't so clear, then it's good to start creating timelines. Okay, so once I went to the employer and I blew the whistle, then all of a sudden I wasn't invited to meetings. All of a sudden I wasn't given the same work. All of a sudden I'm ignored by my colleagues. So you've got to make it clear that there's a connection because the employers will just go and say, but imagining things. I mean, it's gaslighting 101 here that happens. This never happened. She's crazy. What is she talking about? So try and make that connection very clear. Gemma? Right, so an unfair labor practice. So this is when you are still in employment, but something negative has happened, okay? You suddenly transferred, you suspended. Now, what you can do in that instance is you go to the CCMA, you file an unfair labor practice. There's also relevant bargaining councils. So, for example, with local government, there's the South African Local Government Bargaining Council. But certain sectors have got a bargaining council and you've got to go to them because if you go to the CCMA, they're going to say, sorry, we don't have jurisdiction, you're in the wrong forum. So check that you're in the right forum. and then you file your dispute. And then we'll sit for conciliation, which is basically settlement discussions, right? So you try and you settle, you say, look, I just want to go back to my original position. Can you do that? And the employer will say yes or no. These processes are, I'd say, probably around 50-50 successful before dismissal. There's quite a bit of success in doing this. And I think a lot of people just take for granted the CCMA, like they want to be in court, they want the judge, they want their judgment in their favor. But the thing is by then it's antagonistic, you spending a lot of money. Don't discredit what conciliation can do. I had a client recently, it wasn't related to whistleblowing, but there was clear sort of victimization. We just referred to the CCMA. All of a sudden, the employer's attitude changed. And this wasn't a small employer, this was quite a large institution. Because they start thinking, okay, this person's taking this seriously, let's just slow down a bit. Let's just at least follow the procedure properly. And now a lot of whistleblowers don't know about this. They don't know that you can challenge these unfair labor practices while you're still there. You don't have to wait till you're fired. Now, the issue with this process is that if it fails, if you can't settle, right, then you get a certificate of outcome from the commissioner and you've got to refer to the labor courts, okay? And that's money, that's time, that's issues. It's a schlep. And the only way I can explain it is that anything within the LRA that is touching on your constitutional rights, your right to strike, your right not to be discriminated against, all of those matters get referred to the labor court. So that's why it is like that, but don't discredit it because it may actually work and the employer might just go, okay, let's just calm down with this person. Let's pull the handbrake up a bit. Right, then the other issue is that, well, the other avenue is that if you are facing that suspension, that transfer, whatever it is, you can also approach the labor court directly for an interdict. So an interdict is to stop this action. The thing is it's a two-step process. You go there urgent, you've got to say, why are you here on an urgent basis? I want you to be on my normal role. You've got to show that there's going to be some or other detriment to you if you don't come now. And that there's no other way that this issue of yours can be resolved. Now, our labor court is very cautious about this because they say, you've got the CCMA, you've got the bargaining councils. Why are you coming to me? My role is long and stuffed and I am tired. And you've got to remember that just because you feel aggrieved by what's happening, the judge, remember the judge is supposed to sit there with a blindfold. He's Lady Justice. He can't see, he's there to listen to both sides. And who knows, maybe the employer makes an incredibly compelling side. So that's the thing with rushing to urgent court is it can sound very attractive. You think your relief is going to be quick, but it might not always turn out like that. Junaid always says it's how you plead the case. But the thing is, remember, the employer is also pleading his case. And one of the first things he's going to raise is, this hasn't been conciliated yet. I haven't got the certificate. That you've got to show you're going to do it or you're in the process of doing it. And you've got to show what is the irreparable harm. And then you might get your order, but then you've got to come back a second time to make it final. And like in that communication workers union case, when they came back the second time, the judge was like, whoa, these guys aren't whistleblowers. I might have said the first time they were whistleblowers, but I've now had some time to think about it. So that is something to do, but there are some costs that you need to bear in mind. Gemma. Right, then another thing is if you are facing a disciplinary, okay, you're not going to get an interdict. Okay, so by the way, let me clarify this. So you can refer disciplinaries to the CCMA. The thing is the CCMA hasn't got the power to stop the disciplinary. And generally what the CCMA is only prepared to do is to say, no, that didn't warrant a final written warning. So it's all those steps before dismissal in terms of disciplinaries that the CCMA is willing to get involved in. But now you don't have the money for an interdict. What you can do is there is section 188A of the LRA, which says as a whistleblower, you have the right to convert your disciplinary hearing into this inquiry. And now what the benefit of that is it's done by a commissioner at the CCMA. Okay, so you're already guaranteed that you're going to get someone who knows what they're doing. It's not just some, I'm going to say a lawyer because they generally are. It's not just some lawyer that the employer is paying. So there's some level of independence. There's some level of extended knowledge about how these things work. And then also it's going to be a quicker process. So if that outcome, if you're unsatisfied with the outcome, then you just take it on review to the Labour Court and you don't have to go back to the CCMA. Now, the thing is with these Section 188A inquiries, there's been a lot of abuse in the courts about people who are alleging to be whistleblowers, and in actual fact, they would never qualify for whistleblower protection. It's just been a way to delay their proceedings. So if you're running to court to ask for this protection, then you're going to face this uphill battle of the court going, another one. Remember, you're always going to be convincing a judge. So how you do this is you ask your chairperson of your disciplinary, you ask the employer, or you write directly to the CCMA and you say, I'm a legitimate whistleblower, here's my disclosure. Please have this matter dealt with in terms of Section 188A of the LRA. And then you're hoping for better protection in that light. Right, Gemma, can you? Okay. Right, then this is obviously the final hurdle is now you've been dismissed, which is generally where we see whistleblowers. Some of them don't even get the benefit of a hearing. It's just straight, they allege something about unlawful breach of contract. They use all these fancy contractual terms. It was just an unfair dismissal. So you obviously sit for your disciplinary. And also what we tell whistleblowers is, if you're choosing now to face your disciplinary, you're not getting interdict, you're not doing the Section 188A, then make sure you attend and you're prepared for your disciplinary hearing, because that becomes your record. That becomes your record at the CCMA, that becomes your record at the Labour Court. So make sure that that is there. Do not, and also be prepared. Do not just sit and wait that the employer is going to prove your case for you, because they won't. They're going to make sure that they hide everything they possibly can and frustrate you. Also, another issue is be careful about how you approach it in terms of how many postponements you ask for, how many times you file a sick leave notice. Because when you look again, the chair's made a decision that this is going on in your absence because you've been given adequate warning. So that's our advice, is we know that it's not a pleasant process to go through, but if you're not using any of these other protections, at least go to your disciplinary, be prepared, put your best foot forward, and use this guidebook and see if it can help you. Right, but now if all of that has failed and the whistleblower has been dismissed, then again, you go to the CCMA, you refer a dispute of unfair dismissal to the CCMA or one of the bargaining councils, you'll sit for conciliation, and hopefully you can settle, right? Hopefully the employer's like, oh gosh, we were stupid, yeah, we made a massive mistake, let's bring you back. Or perhaps you'll be happy with a settlement amount. The thing is also be realistic when you approach those discussions. If you're just earning 10,000 Rand, you're not going to get R1 million out. You know, it must all be proportional. But now if conciliation fails, which we also see often happen, that employers don't even pitch for the conciliation hearings, then you've got to refer to the Labour Court for adjudication, and it's an automatically unfair dismissal. And this becomes a full-on trial. So you have a pre-trial conference, you and your attorney will meet with the other side, you'll discuss what's common, what's facts are in common, what's in dispute, and perhaps you then approach settlement again. And then you'll sit in a trial, judge, you get put in the examination box, you put under cross-examination. And remember, that's when things like you having skin in the game come up. That's when you get cross-examined. So it's a very strenuous process. There's many things that can come out of the closet, and you just need to be prepared for that. Now, overall, when we've looked at what is the most successful avenue for whistleblowers when they're looking at their matter from a pure labor perspective, is to follow this one. And it's unfortunate that it is this one, because we're looking at, and Bareng, help me here, we're looking at getting a trial date in the Labour Court 4 to 5 years. Yeah, so that's the unfortunate thing. You've suffered your occupational detriment, you go through all of that, and then you've got to wait for a trial date. But unfortunately, those are where we're seeing judges really understanding, really having a lot of sympathy. You see this in the Mashilo versus SARS case. The judge really understood what whistleblowers were going through. He understood what the effects were. He even mentioned the greater detriments on the entire family. But it's where we see, and I don't know if it's just because the judge has a lot more time, but it's where we're seeing the most successful for whistleblowers, unfortunately. So if you're sitting with limited funds and you come to me, I'm probably going to say, you know, wait for this one, as unfortunate as it is. Gemma, can you move to the next slide? Right, so what can you do if you're not an employee or a worker? And unfortunately, there's very few avenues available. You can try and get a protection order. Those are just at magistrates' courts with the Prevention of Harassment Act. So that's, for example, you know, someone constantly sending you messages, they're following you, they're standing outside your house. You can apply for a protection order, although you know how effective that is, but that's your avenue. And then, of course, there's witness protection, but that falls under the National Prosecuting Authority. Together with the SIU can also type of facilitate it, but you've got to then be, your matter then has to have been deemed serious enough to have been taken up by one of these institutions. So again, not so serious. I've also heard some horror stories about witness protection of, you know, people not complying with this sort of maintaining their location secret, and then they get caught out and they're murdered. So those are the two avenues, very little. It's just tragic for what it is. Gemma, can you just go to the last slide? All right, and then another issue which we often grapple with is employees who didn't necessarily do, and I call it like the positive act. So they didn't necessarily go to the employer and say, listen, I witnessed grand corruption. They just said, I'm not going to sign on this invoice. You didn't follow the procedure. I'm not signing it. And then they start getting hassled and harassed. So what do you do in that instance is, in terms of the PDA, you can be protected against harassment. The problem is if a court says, yeah, but we don't see the whistleblowing. You just weren't following instruction. So if you're faced with a disciplinary, you're probably going to be charged with insubordination. Then you say, well, the instruction was unreasonable and unlawful, and I'll show you why. It says that I cannot sign off on invoices if two other people before me haven't signed it. So that's the end of my presentation. It's again focused purely on the PDA and the labor remedies, and it's really just to try and simplify it as best as we can. But we completely understand that it's a convoluted minefield. The other issue is if it starts becoming about not necessarily unfair dismissal, but unlawful breach of contract. And that's generally where the contract is terminated immediately. So we've tried to simplify it as best we can, but please feel free to ask questions, clarify, and how best can we make this guide as easy and digestible as possible.
I don't know if you want to take questions now or we let Zunaid present and then. Yeah. So any questions, comments on the presentation so far? Okay. Over here. So that you don't forget already.
Thanks, Chantal. For me, I think the tragic thing is the timelines. I mean, if you look at the timelines and if you're a whistleblower there, and then you have to spend all your money going from forum to forum, I mean, you might even need a lawyer to go to arbitration in CCMA, and you're spending all your savings. And before it gets to the High Court, you're already finished all your, what you call, your resources there. And then you realize that the other side doesn't have a skin in the game, in a sense that they are paying for the legal cost out of their own pocket. They're using institutional money. And then when you get there, I mean, before even you end up saying, you know what, I leave this thing, I'll focus on other things. So for me, that's really a concern. I mean, when it comes to whistleblowing, what is the incentive then for a person to whistleblow if then you have to subject yourself and your family, for that matter, I mean, to all these legal processes where you have to use all your funds and all that, I mean, to bankroll a legal process that you are not even guaranteed that you're going to win at the end of the day, yeah?
No, absolutely. It's a huge problem. But I think also, you know, until whistleblowers, you know, that's why they must go to PLUF. That's why they must go to PLUF. That's why they must go to Whistleblower House, because they will get, I'm not saying necessarily monetary support, but they're going to get support. And that's why it's good that these type of events happen, because this awareness is created. But if whistleblowers don't get there, then unfortunately we have to just be realistic as any employee would be and say, well, where am I? And it becomes like that cost benefit analysis, right? It's reality. Bareng's going to tell you how he has to lay down the law and say, well, you know, I need a deposit because the fees are going. So it's just a tragic system. But I think, you know, until that new law comes into effect, which, you know, it could be next week, it could be 10 years' time. We've got to work with what we have. And unfortunately, whistleblowers are in the same boat as people who are sexually harassed in the workplace. It's that they go through the exact same thing. So unfortunately, we just have to deal with the realities which are heartbreaking.
Thanks, sorry man. Well, mine is a comment, is to say, well, I didn't want to bring a problem, but when it comes to the referral in terms of 188 capital A to the CCMA, I think such matters, there shouldn't be a need, well, the legal rep requirement should be relaxed in such cases. Like in cases where a whistleblower blew the whistle at the workplace, employer subject or retaliate with disciplinary processes, employee trying to protect themselves in terms of the PDA and the LRA refers the matter to the CCMA, you are still required to convince the CCMA that this matter requires legal representation. And normally, legal representation is not granted easily at the CCMA. However, what is currently happening, and maybe without really decampaigning myself, I used to be a legal advisor for corporate companies. So what companies are doing now, they are hiring qualified lawyers. They are hiring qualified attorneys as their employee relations specialist, as their legal advisor internally. When they send a person to the CCMA, they send a person who's fully qualified against ordinary lay people. And then you come and say, raising a complicated matter like protected disclosure, well, I've made a protected disclosure. Normally, the employer can be very innovative, and a lot of technicalities needs to be exposed. A layperson cannot do it without the assistance of a legal representation. And as I said, you are still required to convince. So my suggestion is, maybe if we can look into persuading the director of the CCMA and the relevant bodies like NEDLEC to relax legal requirements, or I mean the need to still convince, or maybe let me put it in this way, legal representation should be automatic in cases of whistleblower. You shouldn't still be required to convince the CCMA that this matter necessitates a legal representation.
No, absolutely.
I just have a question about how often the litigious process comes out in favor of a whistleblower, because I'm looking at the DOJ's document here, and there's an interesting, and maybe you can comment on the stat itself. So there were 33 whistleblower cases under the PDA, 7 were won, 25 lost, and 21 were lost on the merits, 4 on procedural grounds. So it seems as though the litigious process doesn't really work out in favor of whistleblowers, and I wonder if that's okay. If there's because of a reform is needed, and I just thought I'd want to get your comment on that very curious part of the DOJ's document.
Thanks. I hadn't even looked at those statistics. Just by reading the cases, I could have told you that it goes more in favor of the employer than the employee. And that's sometimes, look, I'm going to be honest, in many of those urgent matters that we see for the interdict, it's not legitimate whistleblowers. It's someone who concocted this theory with their lawyer to try and get relief. And then that unfortunately distorts that number completely. With the automatically unfair, they're a lot more successful than the other matters. And also, it's where you see the whistleblower has really built this case up with their attorneys from the beginning, like in the Thorn versus Department of Health case. You could see that was a very well-constructed case. So unfortunately, given the urgency of court, we don't actually see very good cases going forward. Also, remember, there's no civil society organizations that are pushing these cases, like, for example, with evictions. Socioeconomic Rights Institute pushes those every month. So they know exactly what to do. It's a matter. So there's definitely a need to build up momentum. There's also a need to what's the word, sensitize the judiciary around this. And I think that sensitization is perhaps happening at your constitutional court with Zondo, but we don't see it lower down. We also don't see it at the CCMA. Because often at the CCMA, and Baring, correct me if I'm wrong, you get a lot of tips from the commissioner about how you should frame your case. And I don't think they're helping a lot. So.
It says if in good faith you believe that the employer is initiating the disciplinary process in confirmation of it. But I think even the labor court on your comment to say they should look into that, the requirement that it doesn't in good faith, therefore disclose any information that is irregularities or irregularities or unlawful. It doesn't need to be proven.
Yeah.
In good faith, I believe that the wrongdoing and I order subsequent that I this action and I try to protect myself by running this employer doesn't use it and I mount an application to do that. I think the labor court should take into account the fact that if in good faith I thought there was wrongdoing and I made a disclosure, I should be allowed to enter into the process and finalize the process of application.
Yeah. Was that all work for you?
To make a quick one.
Just a quick one in response to your question, where's the incentive? That's the reason why Justice Goldstone is agreeing with whistleblowers that this needs to be an urgent item on the agenda. And I'm not sure if it is covered in the PDA, Chantal, that you spoke about, but there's no incentive at the moment. I mean, we are currently reeling from state capture. All these bodies that we are approaching for help, be it the CCMA, the HRC, remember they've all been under state capture period. Worst obviously is Parliament. As you all know that Justice Zondo was quite scathing on them. So it makes it urgent, it makes it a societal issue, and hence someone said earlier about the elections next year, because at the moment, there's no incentive for employees, for good, honest employees. There's no incentive for the whistleblowers. It is unfairly skewed in the favor of the employer versus the employee. And I think given state capture, we need to see it from that lens, that we've got a lot of crooks in the system that are presently roaming the streets free, enjoying the rewards of state capture, whereas the whistleblowers have borne the brunt of it. What Justice Zondo also mentioned, that should there be another state capture, they will not come forward and testify. Thank you.
Just on that, I think it's more of a stick scenario here with like PRECA. You've got an obligation to report wrongdoing. If you don't, you can get into trouble, which is what we saw coming out of the Zondo Commission. So yeah, we are with a stick. But there's nothing really to incentivize, and that's where Zunaid's going to come on how can we remedy that?
Yes, and I think before Zunaid, I give you the mic. I think, we've been talking about incentive, and I think more from a monetary perspective than anything else. And I think now this discussion is making me think of, can we speak about incentives more from a labor law remedies, like you push for reforms in the procedure and the duration of the procedures until someone gets a remedy? Is this something that we can maybe forward as an incentive that is not monetary? So that's just for us to maybe think about, and from the legal minds, and what can we push for and what can we ask? Because the duration, the corners that one has to go into and out of, it's not an incentive. Like, I mean, I would not blow the whistle.
Yeah.
All right. Because I will definitely experience harm and damages for sure. Yeah. So over to you.
Right. That's working. Good. Okay. So just wanted to say thanks to Chantal for giving us an overview of the PDA and and the Labor Relations Act. So there's two things I'm going to address with you today. The first thing I'm going to address is looking at the Companies Act. Section 159 of the Companies Act specifically is titled Protection of Whistleblowers. Many people don't know that because they haven't read the Act thoroughly. And there's a couple of other sections in the Act, in the Companies Act, that you need to be aware of. Section 5, Section 7, Section 218 are pretty important. Those sections, all when read together, actually provide quite a strong bulwark for whistleblowers to have access to and to find refuge and protection in. So we'll talk about the Companies Act, and we'll talk about how you can actually sue for damages. I've got a background in law, particularly plaintiff side law, and also having been exposed in the US to qui tam actions and whistleblower actions in the States, looking at how we could bring those legal structures and those legal formulations to South Africa. And we have launched a fairly large case in the High Court using Section 159 of the Companies Act, using the Protected Disclosures Act, and then also using the National Environmental Management Act, NEMA, which I'll also speak to you all about. Because I think one of the things that we've also got to appreciate is that there are many ways you can sue for damages. And Section 4 of the PDA, it came through in the amendments in 2017, did allow for you to sue for damages if you can prove harm, and if you followed the correct procedure that Chantal has gone through, good faith, reasonable belief, and that your disclosure does meet the requirements set out in the PDA. But there are also other provisions in other acts that you need to be aware of that are very important. So that's the first element I'll touch on. The second element I'll share with you, just came about today, was what type of funding mechanisms can we bring forward to help support whistleblowers? And are we going to wait for government and the state to bring this to bear? My view is that you don't have to wait for government to do this. You shouldn't be hamstrung by government and all the sort of toing and froing with parliament, white papers, and the legislative process in order to have access to funds. So I'll show you a short schematic of a solution that is workable, that doesn't require government support, and that can be done by any civil society organization. It's a suggestion. Civil society organizations can decide whether they like to take it forward or not. So let me touch on a word of blowing the whistle. So a lot of cases that I've seen with whistleblowers. So when I take on whistleblower cases, we take them on a contingency fee basis, meaning that we don't we don't charge by the hour and charge our client exorbitant fees until we've won the matter, until we get a successful outcome. So a contingency fee basis is important. But one thing I do see with whistleblowers when they arrive at our doorstep, some of them have arrived through the whistleblower house. In fact, many have, and others have come directly to our law firm. And the interesting issue there is that, like Chantal says, a whistleblower may have blown the whistle 6 years ago, suffered occupational detriment, resigned maybe 4 years ago, and then has come to us. And there's the issue of prescription in our law, a limitation of statute or prescription basically precludes someone from bringing in a claim after 3 years from the date the debt becomes due, or after 3 years from the last sort of factual element that causes or creates the cause of action. So we advise whistleblowers to come to us early on, and preferably to come to us before they've blown the whistle. In the US, there's a very big culture in whistleblowers going to attorneys before they blow the whistle, because the law is complex and it is nuanced. An example of the complexity of the law is if you look at Section 5 of the PDA, you can blow the whistle to an attorney. You do not require a reasonable belief to blow the whistle to an attorney, and you don't have to go to an attorney in good faith either. That's explicit in Section 5. But that's because the legislature took into account that when you go to an attorney, there's attorney-client privilege, and you should be able to discuss with your attorney as and how you wish. And that attorney needs to uphold and honor that attorney-client privilege. But then if you look at disclosing information to the media, Section 9 of the PDA, that's a lot more nuanced. And that requires you to have a substantive belief or truth in what you're disclosing to the media. So there's nuances. If you disclose to a government agency under Section 8 of the PDA, there are nuances there as well. If you're disclosing to the employer, have you followed the internal policies and procedures to make that disclosure? Or have you just gone to the CEO who's not your direct reporting head? Those are all nuances that whistleblowers, the layperson is not aware of, and you'll get caught up in trying to sue for damages if you don't do it the correct way. Like Chantal said, you'll go to court. The judge is ultimately going to be vested with your case and has to look at the law and see whether you've met the criteria in discharging your duty and your obligation to disclose information in a responsible manner. What we don't want is information being disclosed in our country in an irresponsible manner. It must be done responsibly, and judges, when they're seized with the case, have the responsibility and the duty to obviously ensure that this case is before them and it meets the requirements of either the Protected Disclosures Act, the Companies Act, or the Labor Relations Act, or NEMA. So what we've advised, and this is for the benefit of civil society organizations and for whistleblowers, is keep a record of all your communication related to the malfeasance. We've had some whistleblowers that come to us, they don't have all the information, that's sort of very haphazard and ad hoc. Keep a record, keep a file of when you see something going on that's wrong, keep a record, keep a file of it. If you can, save it onto a personal hard drive, because if you are caught out, if you do blow the whistle, there's sometimes an immediate termination of employment services and you're marched out of the building. And I think that's happened to Cynthia in some way or shape or form. She was marched out of the building. That's happened to a couple of clients that I've consulted with. So please keep a record of all your communication. Look after your mental health. This is something the Whistleblower House focuses on, and they realize it's important because people in the Whistleblower House are whistleblowers themselves. And one of the most important things is to look after your mental health. You cannot discharge your duties to your employer in a functional state when you're not looking after your mental health and you're going through retaliatory conduct by the employer. So look after your mental health. Make sure that you're looking after your mental health. Your family is aware to a certain degree of what's going on and are there to support you. And if you can, go to institutions like the Whistleblower House and ask for their support. They do have psychologists on their panel that are specialized clinical psychologists that can assist whistleblowers. Review internal company policies and ensure good faith and reasonable belief. So when you are going to make a disclosure to an employer, or you're going to make a disclosure generally, look at your company policies and make sure that you're doing it in good faith and with reasonable belief. I think that should always be the bar, save for if you want to go to an attorney, you can have those discussions with an attorney without having this reasonable belief, because an attorney will then have to advise you on what you need to look for. Section 1591 of the Companies Act and Section 5 of the PDA are two very important sections. Section 1591 basically says that you are entitled to read the Companies Act in addition to reading the Protected Disclosures Act. Reading the Companies Act is not mutually exclusive of reading the Protected Disclosures Act. So if you do have a case to be tried in terms of Section 159, you can also utilize certain provisions in the PDA, and the judge will have to countenance and balance both provisions or both statutes and provisions that are applicable in either of those acts when taking on or being vested with the case that involves a protected disclosure. So you could, a disclosure made in terms of Section 1596, Section 6 of the PDA and Section 1594 of the Protected Disclosure of the Companies Act, you could use both of those provisions. And there's certain provisions in the Companies Act that actually are a little bit more robust. We'll talk about those a bit later. If you're coming to us after you've blown the whistle, it's always important to consult an attorney. But don't just consult any attorney, consult an attorney who has specialization in protected disclosure law. There are not many attorneys that have specialization in protected disclosure law, but if you can find an attorney that has a track record or is recommended by PLAF or the Whistleblower House or Hill and Suzman Foundation, Corruption Watch, they generally take seriously the attorneys they deal with. I think you may find yourself in good hands there. Protect your data and keep a journal. So once you've blown the whistle, remember to protect your data, because that data could go missing. They could delete your account, your working account, and like I said, march you out of the building. So keep a separate memory stick, and make sure or send it to a drive, a cloud drive that you have, so that an attorney who you deal with is able to look at the information objectively and see what has transpired on a chronological basis. Keep a journal, important. I've worked with a lot of clinical psychologists through medical malpractice suits, road accident fund suits, sexual harassment in the workplace suits. Keeping a journal is important because, and many psychologists will recommend this for people who are suffering from trauma at the workplace, or if they've been dismissed after being in the workplace. Keeping a journal helps you sort of discharge all your thoughts, but more importantly, it also helps corroborate the harm and the suffering that one goes through after blowing the whistle, or after being dismissed, or after suffering retaliatory conduct by the employer, or after suffering any occupational detriment by the employer. Keeping a journal is vital. I'm not sure whether other whistleblowers agree with that, but that's something that we've suggested as well. The stronger your case is, the more likely your attorney will agree to take it on a contingency basis. So the stronger your case is, the higher the chance of success of your case. Remember, an attorney can only charge contingency fees in terms of the Contingency Fees Act if there's a high likelihood that your case will be successful. And if there's a low likelihood that your case will be successful, no attorney, or very few attorneys, I'm not sure I know one, who will litigate a matter in the high courts for 4 years and invest a lot of time, effort, and their money to litigate a matter in the high court on your behalf. So make sure that your case has a strong likelihood of success. And the way you do that is by keeping a journal, keeping all your documentation safe, saving it on an offline platform or separate to your employer's platform. The other important, we've spoken about the psychologist, but the other important thing is that retaliatory conduct can be thwarted. Now, this hasn't been tested in South African courts, in the high courts. It has been done in the labor courts, where an urgent interdict can be brought. And in the high courts, an urgent interdict, the standard to sort of meet on an urgent interdict is, would there be substantial redress for the plaintiff at a future date? It's not to say, are you suffering irreparable economic harm or emotional harm? The real test is, would there be substantive redress at a future date? That's the key test, and there's a really good case law that speaks to that point. And when you're looking at whether there would be substantial redress at a future date, if you're suffering occupational detriment as a whistleblower, you're already being sort of pseudo-blacklisted. You are not going to have any redress, because the amount of time you may be dismissed before the courts come to your protection. And I think it hasn't been tested, but I think there is good grounds to say that if you do bring an urgent application in the High Court, the manner in which you plead your case is important. The defendants are generally well-resourced, multi-million-dollar companies. They will bring very senior people to come and try and push back. But ultimately, if your case is strong and you plead properly, the judge has to see the fact that you are a whistleblower, given the current public interest that we have in protecting whistleblowers, given the current corruption that we have in our country. The judge is seized with that, has to turn to the Constitution, has to look at constitutional provisions and ensure that they are making a value-based judgment and seeing whether this person is going to get substantial redress at a future date. The argument can be made that no, they won't, because by the time they get that redress, they'll be unemployed. They won't have any sort of means to financial means, or they may have suffered severe occupational detriment, trauma. We've had some clients or potential clients who've actually ended up in psychiatric wards because of making a disclosure, doing what they thought was right, having these hostilities waged against them, and then not knowing how to cope mentally with it and ending up in psychiatric wards. Okay, so we can go to the next slide. So use the Companies Act if you can. Now, I mentioned a couple of provisions, Section 5 and Section 7. Section 5 speaks to the fact that, or it talks about how you interpret the Companies Act. So Section 5 basically says that any legislation that's interpreted alongside the Companies Act is secondary to the Companies Act, and the provisions of the Companies Act prevail, save for certain legislation. The Labor Relations Act is one of them. The Financial Markets Act is another statute that must prevail above the Companies Act, and there are a few others. But the PDA is subservient to the Companies Act in this regard. So that's very important to note. Albeit there is Section 1591, which says you can interpret both the PDA and the Companies Act together. Section 7 is a very interesting provision in the Companies Act. Section 7 of the Companies Act essentially speaks about the purpose of the Act and why the legislature introduced the Companies Act and what the Companies Act is supposed to do. There's a specific provision in Section 7 that speaks to the Companies Act being utilized to fulfill the constitutional mandate of our country. And that's very important because if we look at the Constitution, Section 9, and maybe a constitutional law professor in this room who can assist me, but I think Section 9 talks to equality, Section 10 talks to human dignity, Section 23(1) talks to access to courts, and there's another provision that talks to security of the person as well. Those are all in the Bill of Rights, and the judiciary has to interpret Section 7 in that light, or the entire Companies Act has to be interpreted in light of Section 7(1). There's another provision in Section 7 that says that the Companies Act must prioritize transparent, accountable, and good governance. When interpreting the Companies Act, that's the way we need to interpret. Is there transparent, accountable, and good governance? And if not, well, the judge needs to interpret the Act to give effect to that provision. Then we look at application. Application looks at we look at Section 1, which defines a company, and then Section 8, which talks about the different types of companies that are contemplated in terms of the Companies Act. So Section 1 defines a company, which is pretty straightforward, and Section 8 talks about the types of companies. Importantly, you can have a private company, a personal liability company, a non-profit company, a for-profit public company as well. So it covers a wide array of different types of companies, and that's very important. So if we have Eskom SOC Ltd, which is the official sort of name of Eskom, which is Eskom State-Owned Company Limited, or you have Transnet SOC Ltd, these are all state-owned companies, okay? And they are recognized by the Companies Act and are therefore subject to the Companies Act. So you'll have to look at who is the whistleblower working for, who's the employer. Are they a listed company? Because if they are a listed company, then you've got to look at Section 1597, which I'll touch on later, which requires listed companies and public companies to have procedures in place that are communicated to all employees about how to blow the whistle and what the mechanisms are, and ensure that whistleblowers are protected. The macro rationale for public sector accountability is important as well. And I think we've touched on in sort of the first presentation. The macroeconomic rationale is we are taxpayers. Our taxpayer money needs to be utilized to do good. And if our state-owned companies aren't functioning well, our tax money isn't being put to good use. That decreases our credit rating. That also would impact not just our credit rating, but our lending rates. We currently have quite a large lending amount at the moment, fiscal lending amount. So it impacts our interest rates that we have to pay. And then it also impacts investor confidence in our country as well. So you got to think about your taxpayer money and how far does it go and what is it actually being used for? And if state-owned companies are not being held to account and are not accountable, then our tax money is basically being used to foster malfeasance, corruption, and incompetence. It decreases investor investor confidence in our country. It also increases the lending rates that we have to pay, and it also starts to sort of disintegrate the moral fabric of our society. And I think we've spoken about that. And just to touch on it is, you know, how do Ben spoke about how do we change our culture? And in law, you sort of look at, does culture influence the law, or can law be used as a tool to influence our culture? And that's the whole point of the Constitution. If you look at the certification case for the Constitution in 1994, 95, they spoke, Arthur Chaskelson and the sort of justices in the court at that point spoke about the importance of law being used as a tool to change society and to help society aspire to overcome apartheid and be a rainbow nation, a democratic society. And I think that this is very important. So when and to whom was the disclosure made is the next important question. Section 1593 establishes the entities to whom a disclosure should be made. So in terms of the Companies Act, you have to make a disclosure to predefined entities. Those predefined entities or persons can be people inside the company or outside the company. If you would like a list of those entities, there's about 7 of them. You can get that in the guidebook. I don't know them from the top of my head, but you can definitely get that in the guidebook. Yeah, so the CIPC, the Companies Tribunal, an exchange like the Johannesburg Stock Exchange, a legal advisor, so a lawyer, a prescribed officer in terms of the Companies Act, a director in terms of the Companies Act, company secretary, an auditor, either external or internal, or a board committee of, such as the Social and Ethics Committee. So those are to whom a disclosure needs to be made. So that's also important why, if you're thinking of blowing the whistle and you don't do it in accordance with Section 1593, you jeopardize and imperil your entire case. And these damages suits, which we'll touch on, can go beyond 20 million Rand in damages that we are pushing for. We feel that the damages suits are not only going to benefit the whistleblower and compensate the lawyer, but they're also going to dissuade companies from treating whistleblowers like they always have. You've got to hurt companies where it hurts the most, which is their pockets. If it hurts their pockets, shareholders get concerned and start to kick up a fuss and say, well, what are you doing about whistleblowers? Because it's hurting the bottom line. Section 1593A talks about good faith, and 1593B talks about reasonable belief. When you're looking at good faith, the most important thing you've got to look at is, am I blowing the whistle for an ulterior motive? That's one of the main tests in the Chichonga case. And if there is an ulterior motive, we would advise that you don't blow the whistle. And the other question is, am I doing it for personal gain? But personal gain other than any reward or compensation provided for or mandated by law. So am I doing it for personal gain, for a promotion or something like that? Then you've got to think carefully about whether you want to blow the whistle. Reasonable belief, Chantal has gone through that as well, so I'm not going to labor that. And then does your disclosure show a listed transgression? So in terms of the Companies Act, you can't just disclose information on any topic. It has to be on something that's listed in the Companies Act in terms of Section 1593B. And 1593B, the list of transgressions, will be in the guidebook. I can't recall them offhand, but they're very broad. So an example would be 1593B1, which talks about any act or conduct that is unlawful in terms of the Companies Act, or any other act in terms of Schedule 4 of the Companies Act. And Schedule 4 of the Companies Act lists a couple of acts like the Banks Act, the Credit Act, the Financial Markets Act, and other acts. So it's very, very broad. Another provision is any conduct that's set to harm an individual or the environment, which then has an overlap with the National Environmental Management Act. And I think one of the most important things that we've got to also be aware of is who can be a whistleblower in terms of the Companies Act. So we've heard in the first session, we heard it can only be an employee or a worker. That is legally not correct. You don't only have to be a worker or an employee. And so Chantal's correct that you have to be a worker and employee in terms of the Protected Disclosures Act. But in terms of the Companies Act, it's a lot broader. So in terms of the Companies Act, you can be a director, a company secretary, a registered trade union, a supplier of goods to the company, an employee of the supplier of goods to the company, an employee of the company. So it's very broad. And the fact that it also allows shareholders to have a right of recourse. You don't have to be employed by the company. You don't have to be on the board of the company. You can be a shareholder of the company. You can hold one share of a public entity. And if you know that there's malfeasance going on, you can blow the whistle and have the protection of the Companies Act. Those types of cases haven't been brought before court, but in law, there's provision and a framework for it. Next slide. So take it step by step. It may be a long journey. We have heard it may be a long journey. The one thing you've got to know is that retaliatory conduct can be thwarted. The way it can be thwarted is because the PDA and the Companies Act and NEMA have provisions to say that no harm, harassment, retaliatory conduct can be waged against the whistleblower if the whistleblower has made a disclosure a protected disclosure in terms of the PDA or a protected disclosure in terms of the Companies Act or NEMA. So the question then becomes, if I blow the whistle and then the employer starts disciplining me, I can't just say, well, I've made a protected disclosure, you're not allowed to do that. The employer will say, well, who are you to tell me you made a protected disclosure? That has to be something that needs to go before court, and you need to get a court order for that purpose. So what we suggest is take the chance, go to urging court and have a court order ordering that, a declaratory court order declaring that you are a whistleblower who's made a protected disclosure in terms of the Protected Disclosures Act, Companies Act, or NEMA. If you have that order, then you can go to your employer and say, well, you can't do anything that's going to harm me. You can't have any you can't do anything that's going to be seen as occupational detriment towards me. I can't be fired. I can't be disciplined. And then the interesting question then becomes, to what extent can the discipline be done in terms of things that are totally unrelated to what you blew the whistle on? Now, that's a very interesting question, because the Act protects you insofar as the discipline is related to what you blew the whistle on. So if you blew the whistle on financial corruption, but then they're disciplining you for insubordination and things that happened 3 years ago, which I've seen, I still think that the court will look through that and say, well, these are just trumped up charges, disciplinary charges that are being brought against this employee, and this shouldn't stand. These steps will be in the guidebook, but these are just very practical steps that you can follow as you go on your journey. And this is directly to the whistleblower, is, advising you on what you should look for, what you should ask for from your attorney, because oftentimes people will come to us and they're totally in the dark, and I don't expect them to know anything, but with a guidebook that allows them to see what they should be asking, what they should be considering, I'm hoping that this provides just a little bit more clarity for whistleblowers. But yeah, it's just a practical guide. So we can go to the next slide. Okay, some benefits of using the Companies Act. We did talk about the protection. So the one form of protection is qualified privilege. Now, the concept of privilege is mainly in terms of defamation law. So if I go to the media and I talk about a petrochemical company doing something wrong in KwaZulu-Natal, and I tell the media, and then they sue me for defamation, I would have privilege, and they wouldn't be able to sue me by virtue of the fact that I've made a privileged comment, which is in the public interest, which is both factually correct and in the public interest. So the same thing applies. Section 1594 talks about qualified privilege. Now, qualified privilege in the whistleblower space basically means if I disclose that a big multinational is currently paying bribes to a certain government agency, and I have factual information, I'm in the finance department, I have reasonable belief, I'm doing this disclosure in good faith, they can't sue me for defamation. Because if you are a listed company in the capital markets, what happens if I disclose information like this? Well, shareholders will react. If this goes out into the media and we have information from a very senior finance professional in petrochemical A that bribes are being paid to government officials to get mining rights, the financial markets are going to react, okay? And then what happens? There's a defamation suit coming my way. But in terms of this provision, I've got qualified privilege, okay? Immunity from civil, criminal, or administrative liability, that's 1594B. So basically a further layer of protection against retaliatory conduct, which you spoke about. I still think that you have to go to court and get an order. You can't mero motu in your own standing say, well, I made a protected disclosure. That's not going to stand. And I don't think a court would agree with you if you did say that. So you'd have to go to court and get the court's protection, get a declarator to say that you did make a protected disclosure. Onus of proof. This is not in the PDA. This is in the Companies Act. It's the only provision nationally that I'm aware of that has a reverse onus of proof provision. And the reverse onus of proof provision basically says, in terms of subsection 1596, that the company is required to prove that it did not intentionally threaten or mete out any type of occupational detriment against the employer intentionally. The one thing about the Companies Act that comes a bit short, falls a bit short in my perspective, is that you have to show intention by the wrongdoer. So there must be some form of intention, and that's in section 1595 of the Companies Act. So there has to be some sort of intention or threat of intention that the company has displayed. So a threat of intention could be, you know, if you disclose this information, there's going to be consequences, and I don't know if you're going to have a job next month. That's a threat of intimidation or a threat of detriment. So it is quite broad, but you have to show intention. That's why I say record everything that happens. And Chantal says, come speak to us before you blow the whistle so we can guide you on how to equip yourself so that when you do go into these circumstances, you are well-versed and well-equipped. Duty on public and state-owned companies, we spoke about section 1597. So a public company is a listed or traded company that lists its shares, and state-owned company is a state-owned company in terms of the act. And that brings me to sort of almost the end. That's the end of the Companies Act. And then we look at NEMA. So you can go to the next slide. Thanks. So NEMA, basically what NEMA has is one provision, section 31 of the National Environmental Management Act. And the question you've got to ask yourself if you're a whistleblower, and we currently do have a case before the High Court where we are suing for a considerable amount of money on behalf of a whistleblower that was brought through the Whistleblower House, is do you have a reasonable belief that your disclosure shows an environmental risk? So if there's any element of environmental risk that your disclosure shows or will show, then NEMA comes into play, because section 31 of NEMA talks about the protection of whistleblowers disclosing environmental risks. And then you also, the section 31 of NEMA also requires you to make your disclosure with a reasonable belief and in good faith as well. I also suggest that you consult your attorney before making the disclosure, and you have to make a disclosure in terms of NEMA to one of the listed entities in terms of section 31.4. Now 31.4 basically lists out a couple of entities, including the South African Human Rights Commission, the relevant Department of Forestry, Fisheries and the Environment, and a couple of other departments and government agencies. But you can also disclose to your employer as well, provided that you follow internal procedure, if there is procedures to be followed in terms of blowing the whistle. You can also make a disclosure, and Chantal highlighted this, in terms of section 315B, to the media. Now, if you want to make a disclosure to the media in terms of, on any environmental risk element, you've also got to be very careful there. It is broader, meaning that you don't have to first go to your employer to try and disclose information and show that you've tried to highlight this to your employer. You can go straight to the media. But if you go straight to the media, you have to show that there's impending harm to your life or risk to your employment, or there's impending harm or risk to the environment. And that's section 315B. And that's also very important because that allows you to take very important information that's in the national interest. If there is environmental harm, it affects all of us. And with the increasing sort of importance of climate change and fossil fuels and big corporates that are not willing to sort of heed the call, or the importance of trying to decrease their carbon footprints, this is important. And often what we see in environmental cases is that corporations will sort of pollute the environment, and the people who suffer are those in downstream users, farmers, rural dwellers who rely on the environment for their living and for their sustenance. Like we said, NEMA also has a prohibition on threats and harassment where you disclose or intend to disclose information. That's in terms of section 318. Again, you'd need to get a court order in order to prove that you've made a disclosure in terms of 31 and that you are protected in terms of 318. One suggestion would be that maybe we allow a rebuttable presumption that the person who's claiming to be a whistleblower is in fact a whistleblower and has made the disclosure in terms of those provisions, and the employer would have to then go to court to disprove that presumption. I hope everyone. And then there's no closed list of who qualifies. That's important. So in terms of the Companies Act, you have to be a shareholder, registered trade union, employee, company secretary, and a few others. In terms of the PDA, you have to be an employee or a worker. In terms of NEMA, you can be a person. The only important element there is the substantive information that you have must relate to an environmental risk. And we go through a case which Chantal looked at quite deeply regarding NEMA and how the Labour Court looked at this act in a whistleblower case. Next slide. That's it. Any questions or?
Can I? Pim, a quick one? Okay.
If a person follow all the procedure correctly, play by the book, but that person was part of corruption that we're not aware of as a public, but for whatever reason, good or bad, that person decide to come forward and say, here's a corruption here, and that person is implicated in the corruption, but the public was not aware, but it gives us good information that saves the money, saves the company, or saves the government. Is that person regarded as a whistleblower?
Thanks very much for the presentation. I just wanted to understand the reverse onus or rebuttable, was it a rebuttable presumption, and whether we should be advocating for that in the PDA as well, if it's already in the Environmental Management Act.
Okay, should I take on the, so my understanding is that you can't go to court with dirty hands. And as far as I'm aware, the PDA and the Companies Act won't come to your aid if you're complicit in the malfeasance or the corruption. So you may be sort of in the loose term a whistleblower, but you won't be able to seek protection. Chantal? Yeah, absolutely. So yeah, you can't be complicit in the corruption when it suits you. I know that happens in criminal law. I'm not a criminal lawyer, but you can turn state witness in prosecutions where you then may have a reduced sentence. It may be a mitigating factor, or you may get off on just a fine, but not as far as I'm aware in the whistleblower space. And then the question on reverse onus, I think there is a legal slight legal difference between reverse onus and rebuttable presumption, but for the purposes of this answer is just, if I as a plaintiff go to court, I need to prove the conduct of the employer. And if I have to prove the conduct of the employer, in this case, let's say there's some sort of occupational detriment. They disciplined me, charged me with fictitious charges. They spied on me. They followed me home. And these things have happened. I'm drawing on what I've experienced from other whistleblowers that I've consulted. They've fired me and withheld my pension, which happens. I don't have to prove that in court. Normally, the plaintiff would have to prove that on a reasonable belief. So there must be a reasonable belief that this happened. But what this provision in the Companies Act, not NEMA, does is it shifts the onus to say it did happen. Now, the company needs to show or disprove that this type of conduct was carried out by the company. And if it was carried out, what were the justifications for that? And from what I've seen, companies take liberties to try and justify the conduct. But when you really look at the case, any well-versed judge will be able to see straight through that. And any well-pleaded case with good facts, with good witness testimony, with good chronologies, will be able to disprove the company.
Thank you. Thank you for your presentation. I think I think that the guide is very good and it will be very useful. I'm Cameron Jacobs from the Public Service Commission. I think, though, just in terms of the guide, however good it actually is, it is good, is that I would imagine with whistleblowers or potential whistleblowers, it's a very fluid situation. And to grow chronologically or in that systematic way, it's not reality. You are filled with a number of emotions. You're faced with a plethora of pressures on a daily basis, on an hourly basis. I mean, an acquaintance said to me not so long ago is that he's a senior person within the public service. He says, you know, Cameron, I've got just a special savings account, just in case something happens. And that is the reality with often in different departments of the public sector. In addition to that, because I do think it's important for us to look at the reality. In addition to that, and this is so big, it goes beyond the guide, but I will get to the point that I want to make, is that even the macro organization of the state is insufficient to deal with, and the institutional capability of the state is insufficient to deal with whistleblowers. So you spoke about the SIU early on, you spoke about the MPA. SIU was fraught with its own corruption and malfeasance problems. So is the MPA. Institutionally, the investigating director is doing very little because they just do not have the capability. And that's the reality. What many people don't know, but that is reality. The point that I want to make is that I think that, I mean, you spoke early on quite eloquently about culture and law. And I think a way needs to be found to popularize this. And not to have the discussion amongst ourselves all the time, but to popularize it in our society. You spoke about Section 9, Section 10, Section 12 of the Constitution, which is particularly pertinent. But we have reached the stage in our own country, in our own society, where those fundamental rights have become paperless. it's just worth its relevance in the Constitution, and that's it. And I was just thinking, as you were making the presentation, the Public Service Commission is going to, we hope anyways, that going to embark on a national advocacy campaign in next year on the constitutional values and principles. And we're looking at a 12-month campaign. And I was thinking that, you know, we're looking at October, for example, as sort of governance month, and whether we should try and look at popularizing and educating and advocating around the Protected Disclosures Act and the protection of whistleblowers in that governance month. And I think that maybe we could have further discussions on that. Thanks.
Any hands?
Junaid, in your last slide, you spoke about reporting in the media. I would presume that it's reporting to the media anonymously, right?
Well, I think the media would, the NEMA doesn't say that it has to be anonymous. The NEMA doesn't say it has to be anonymous. Whether media outlets for your safety, in the reality which Mr. Jacobs talks about, you know, from a safety perspective, let's make it anonymous until you don't want it to be anonymous. Because there have been whistleblowers who haven't been at the State Capture Commission but have spoken out to media after being dismissed and have been anonymous to the point where they said, okay, well, now let's lift the guise of anonymity and show you for who you are, so that there's a face to the whistleblower. But we obviously faced with realities in our country that if you do show your face, you'll have crosshairs on your back. And that's something that whistleblowers need to be sensitized to and aware of. And lawyers need to be aware of that. Civil society needs to be aware of that.
Yeah, no, so it was definitely from that perspective, whistleblower safety.
Yeah.
We saw last week how those witnesses were taken out.
Yeah.
Because those 4 cops that assaulted them, they knew who this person was, you know?
Yeah.
Thanks.
Yeah. And then I think to one of Jacob's comments was, you know, how can we do it when whistleblowing is so fluid? The reality is that it is very fluid. And I think Plath and Whistleblower House are more at the coalface than we are, of seeing how fluid these processes unfold, how quickly these processes unfold and how fluidly they unfold. But your chances of success in court are so much higher if you are able to seek guidance. Your chances of success at life and managing yourself are so much higher if you are able to get psychological treatment and psychological care. You can't do it on your own. It's a huge cross to bear, and having that support, you know, would only assist someone in the long term, particularly where they're suing for damages and trying to get these types of cases before the high courts.
Not really a question, but your slide spoke about make sure your first consultation in this long journey is free of charge. We've made submission, as I said, as an active citizen movement to the Zondo Commission, working with about 30 whistleblowers. Many of those whistleblowers, Cynthia, if I remember, lawyers would not see them without a down payment. So the thing you spoke about, you know, free of charge, I think it's wishful thinking. It would be nice if we can really look at all of that, because I think invariably, you know, lawyers also have to earn a living and they also have to pay the bills. Yeah. But if we have this kind of situation when, like for whistleblowers, Justice Zondo was saying there was an issue about them abusing this thing about incentivizing. And he said, so what? As long as they can expose all the rot and they can get compensated once the payment kicks in. Mm-hmm. And I think likewise, the same applies to lawyers. Thanks. Yeah.
Yeah. One point on that is that there are lawyers on the plaintiff bar and plaintiff side lawyers that take on cases in the medical malpractice space, for example. And that's a sort of, it's become an industry in and of itself, where lawyers take on cases, do not charge a cent until they win the matter. That's because there's a tried and tested process for winning a medical malpractice claim. And oftentimes the cost of doing that, just from paying out experts to prove your claim, would be north of 200,000 Rand or 300,000 Rand. And your fees in the matter are going to be in terms of the Contingency Fees Act when you win that matter. If we can do the same thing for whistleblowers, where whistleblowers are able to attend at a first consultation and not have to pay any fees, and then going forward, working with a civil society organization, pay a bare minimum rate to have you on retainer as a law firm, and then take your case on contingency, then they're not paying a cent for you to represent them as a lawyer. And where you do require counsel's input because it is very novel fields, these are novel fields of law that haven't been tried and tested in our courts, they need to go through courts. And we need to see that judges are not having it. And when we do get good precedent, then that's when other lawyers will wake up and say, hey, I can take this on contingency, sue for damages of 20 million, and take 25% to double my fee rate, whichever is the lesser. That's in terms of the Contingency Fees Act. And then you have an industry of lawyers, like we do in the States, where they're willing to take these cases on because it makes financial sense for the lawyer, and it incentivizes the whistleblower to get the damages claim at the end of the litigation road. But with any novel field of law, it takes a few brave clients and willing lawyers to try and test this field. And the reality is, I personally don't believe in waiting for government to give us answers. I believe in creating answers that we can create based on what we have. The last thing I wanted to show civil society organizations here was just a structure of a trust structure that can be set up that can start funding whistleblower cases. Just want to pull it up. So this is a structure that we've put together. It's just thought of how you can fund whistleblowers in whistleblower cases. So essentially, you'll have a couple of successful claimants at the top who are actual whistleblowers who basically take cases on and win these cases. And they sue for damages. And if they do sue for damages and they're successful, they can voluntarily, at any stage of the litigation, make a discretionary donation to a trust. Now, a trust only needs to be formed at the master's office by virtue of a trust deed, and that trust deed must then have a board of trustees. Board of trustees would be, people with integrity and honesty who would sit on the board of trustees and manage that trust. And every time whistleblowers are successful, they can make a discretionary donation to that trust. 5%, 10% of their winnings go in there. And that trust then is capitalized. And the bigger the capitalization of the trust, the more types of whistleblowers they can fund. How they use that capital is they fund a whistleblower organization, a civil society organization, such as Whistleblower House of Pla, to then utilize those funds and utilize those funds for litigation purposes, for provision of psychological and therapy purposes to whistleblowers. So it's a very straightforward process. The only thing that we require to get the process started is to have successful claimants at the top. And there have been successful claimants in terms of the PDA in the High Court. Chowan, in the case of Amalgamated Motor Holdings versus Chowan versus Amalgamated Motor Holdings, it was Mark Lamberti. Anyone remembers Mark Lamberti, sort of a big corporate icon? Oh, Miss Chowan is in the audience. So her case is brilliant because it actually shows how the PDA was utilized to actually bring about a successful claim. What the case doesn't tell us is what the quantification of damages was actually, but you guys probably settled that because it wasn't before court on the quantum aspect. It was only at court in terms of the merits aspect. And Ms. Chan is now at the bar and is an advocate, if I'm not mistaken. So she's sort of been through the fire and has been at the coalface of this. And that's how you can do it. If you get successful claimants who know what it's like and are willing to donate to a trust. Why do you need to wait for government to do it? And do you trust government to donate or utilize those funds effectively and efficiently? A case in point would be the Road Accident Fund. They get billions every month from fuel levies, which is our money, and currently not being utilized as effectively as it should be. The PSC was involved in that whole process in investigating the fund, and the SIU's been involved in that as well. But there's just no answer. And our funds just keep on getting wasted. So why must we spend more taxpayer money? You could do it amongst civil society and really start to fund these cases.
It should be the claimants who are the ones who need to contribute to the structure. Why not the lawyers that have made money out of the whistleblowers have gone through a lot. They've incurred costs and all that. And why also not the public?
Yeah, that's a great point. And I think that's sort of my narrow thinking. Sometimes I need people and the truth of the matter is anyone can capitalize the trust. Anybody can. So any interested individual, whether it's the Friedrich Naumann Foundation or any entity, can capitalize the trust. Any investor can, if they feel that they want to donate to the trust, they should.
Sorry, just a quick point. Now that we've brought Adila into the conversation, I've worked with Advocate Adila previously in the whistleblower submission as well. And earlier on, she was not here when Kavisha spoke at the panel discussion about the Human Rights Commission being a potential body to look at whistleblower excuses. Now, Adila, when we spoke previously, you spoke about the link of whistleblowing to human rights and to the labor bill. You might want to give an input to advise where you are coming from, because it provides a lot of light onto because we had state capture, institutions were captured. And is the human rights body well placed to look at this? Because we spoke about labor and human rights being linked to whistleblowing. Maybe it'll be good just to get Adila to give a quick input. So sorry to pull you into it.
Good afternoon, everyone. Perspective, it was to try and create an independent body and to fast track the process. From my own personal experience, I've got a couple of cases on whistleblowers at court. And there is one matter that started in 2018, and we had to move the date. We had a date in November, and we moved it to next year because we needed 14 consecutive days based on the number of witnesses. And this is unfortunate because by then, whistleblowers are obviously financially strapped. They lost their houses, they've lost their cars, their marriages have broken down. So one way to try and address it is to get something set up within the Human Rights Commission to fast track the, even if it's like a first place, because from my personal perspective, I've seen CCMA does not have the skill set internally. And in most instances, you approach them and then they just refer it to Labor Court, which is indeed the case that they should do so. But it goes to show that the so-called place where you should have free legal support is non-existent then. So because once you go into labor court, there are cost implications. The other thing I did find in labor court when I went before a judge as well, she was like, your client had the option before getting dismissed to go to the CCMA. So they now tend to be a little bit more difficult on the whistleblowers. They're pushing some, to some extent, they're pushing it onto the whistleblowers to justify their conduct. And even going to the media, this one candidate, she actually tried to whistleblow internally, wasn't successful, but she didn't wait for the process. And then she tried to escalate it and even went outside. And those things turned on the whistleblower. So hence we needed to find a place where it was safe while you are employed to then approach, if it's situated within Human Rights Commission, might make it easier and obviously more independent And the other thing that I heard you mention, the section 188A, the one where you are being disciplined, to have the disciplinary heard in terms of you being a whistleblower. Not everyone is aware of that. And then by the time they get to High Court, they've actually compromised their case, and we are struggling to try and fix it at that point.
Yeah.
Thanks.
Yeah.
All right. Okay. There's one more.
So can I just make a comment on the South African Human Rights Commission? And I saw that in the submission. They were recently before Parliament to report on their annual report. They achieved not even 50% of their KPIs. They are not, they suffer with high turnover of staff. There was one person who was there who was trying to take on whistleblowers, and now he's left, and they seem to be focused more, it's either about race or it's about water and land and sanitation. That seems to be where the skill set is. So unless there's an accompanying plan that the Human Rights Commission is going to be capacitated to deal with it, I think whistleblowers are going to have the same problem running to that institution, which they already do now, and we would have to change the law as well. So the SIU, I mean, I was at an event last week. They have a little pamphlet that says, what must you do when you want to blow the whistle? So I think there are other institutions that are much more willing to take it on than the Human Rights Commission, which just seems broken to the core. Like they need a massive overhaul, whether it's just legislatively or management. I'm not sure whether, I haven't done a trouble spotting solution there, but that institution is broken.
This is institutions we think may, but I believe it up. I mean, I truly believe it. Not for one part. So it's not, let's make an informed decision about certain things. Before we just say this, go to the Human Rights Commission. We use that proposal around a new chapter and dig whether that's going to see the light of day, I don't know. But the point is that when we're looking at staying attached, we should also look at these chapters, including the part. Right. That was one way, one form, capture. That is why it's okay at us, because we were these chapters. Then stay captured.
Okay, my name is Biswick. I'm from Malawi. I just have got two questions or some of the observations that you should take into account. A whistleblower can be someone who has not benefited from the corruption activity, but also can be someone who has also benefited from the corruption activity. In Malawi right now, we've got a case, and one of the key persons who benefited from the system, from the case, was turned to a state witness. Now, in your guidance, if I heard everything properly, you have provided guidance in relation to a whistleblower who is not part of the system, who has not benefited from the system. Because I believe and I know that some people may benefit from the system, but eventually they may make a decision to say, I need to blow this. What is your guidance in relation to this?
Well, the guidance so if I understand the question correctly, it was if someone hasn't benefited from the corruption and is not part of it, how should they blow the whistle on it?
Someone who has benefited from corruption but wants to.
Yeah, because so basically saying the guide is for people who basically ideally have not benefited or are not complicit. So what about those who benefited and then also had now a conscience,
to come forward.
To come forward and become state witness or
Yeah, well, I think Chantal and I would suggest to do it anonymously, as far as possible. Personally, I actually haven't come across a case where someone's come to me and they've been complicit in the corruption. But that's an interesting question. I think the only suggestion at this stage would be to do it anonymously to the media, and then let the investigations take place. But that's the only. I don't know if you.
I mean, the other one is to do a 201, like with the Brett Cable murder. You know, the murderers came forward to the police and said, "Yeah, we were ordered to do this hit." And they were given protection. They just needed to testify because they weren't the big kingpins in that crime. But it's difficult because the prosecution might not give them the protection, so it's a risk they've got to take. Do they just want this off their chest and they want to hopefully get into heaven, or?
I think maybe my contribution in terms of this relevant question, we do have such a case. Remember the Bosasa case of Angelo Agrizi.
Yes.
That's one player who was implicated in all the criminal activities, and then he's turned state witness. So is he a whistleblower or not? I think that would be the question. And I would argue that he turned a whistleblower because he's the one who got to expose the underhand dealings. And in such a case, probably that's where witness protection kicks in. And we then need other, stakeholders to play their part, law enforcement, to protect such kind of whistleblowers.
I think there's important distinction to be made between being a whistleblower and having made a protected disclosure. So, you know, I think in order to make a protected disclosure, you have to meet the requirements in terms of the legislation to have that protection. But I think you're quite right that, you know, if someone does turn state witness for a commission of inquiry, they could be termed a whistleblower, but they wouldn't have the protection of the Protected Disclosures Act or the Companies Act. But I think the state will offer them some sort of relief. Chantal, I'm not sure.
If I decide not to grant you protection, it's their decision. So it's a massive risk.
But I think with commissions of inquiries, there are processes where you can come forward and your rights and the repercussions are sort of set out for you before you go to testify at the commission. And you then may look at that and say, well, I think I want to partake in this commission. I mean, we've had many commissions, the State Capture Commission, the Nugent Commission, which I think focused on SARS. So there's been several commissions, cost the taxpayer a lot of money. So we need to see the results, and having people like Agrizi come forward does help. But it doesn't offer him the protection of the Protected Disclosures Act or the Whistleblower Act. You wouldn't be able to claim compensation, but you would be able to have some sort of witness protection. And like Chantal says, that depends on the facts. But good point.
I think maybe another thing that should be considered to address the question that my brother and my brother there are raising is what was, I think at some point proposed by Tulima Donzela, corruption amnesty, to say people are encouraged to come forth and they are granted some sort of immunity that going forward, should you get yourself involved in this, then there will be serious consequences. That is my thinking that can address this. And the other thing that I wanted to maybe just make a comment on is that whistleblowers should be made aware or should be educated to know that whistleblowing, if it is indeed whistleblowing, is not a misconduct. There's nothing wrong with it. And the reason I'm saying this is that there's a case, a real case that I once dealt with. A lady whistleblowed in one of the parastatals or state organizations. She then was subjected to disciplinary processes. She successfully interdicted the process. And then they said, okay, whilst pending the disciplinary hearing, you are not allowed to come to the workplace. We're not going to discipline you, but you're not coming to the workplace. During that time, she applied for employment, and she fortunately got a good job in a corporate company. But when she was being recruited in that corporate company, then she committed a misconduct in that she didn't tell the HR that the reason I'm leaving from my previous company, there are these issues going on. And then somebody, I think maybe possibly from their previous employer, they contact that corporate company through the corruption hotline. They notify that, do you know why that person left their previous job? Forensic investigated, and it was found that even on the onboarding documents, she didn't disclose. In fact, she lied. She said that I'm leaving for greener pastures, and no. Well, potential employers, they put this question in the recruitment document: past or pending previous misconduct or criminal charges. So she answered no. And then that was her downfall, because now there's an actual misconduct. In the previous disclosure of irregularities, there was nothing wrong. But in the second employer, she committed a misconduct, and that was a disciplinable misconduct. So I think maybe that happened as a result of not knowing that I could disclose this. And maybe even HR personnel must be sensitized that you cannot utilize such information adversely against the job seeker.
So I don't know if you have any final comments or anything to say to wrap up the. No. Okay, but I think they did some wonderful work, right? Can we just give up to them? And because we were always wondering, what are we missing? What is it that we're missing? How do we give some guidance for whistleblowers, for ourselves as organizations, on how to support better, differently? And it all went back to the law. The GAP book really gives us what the reality is. There are certain things that we want, as activists, that we wish could be done differently. We wish, people were more lenient and kind and understanding, but that is not it. The law is not emotional. So sometimes as activists, we help our people from an emotional place, sympathetic, empathetic, but then the law says, but what did they do? Did they follow procedure? If they didn't, well then, right? So we're hoping that this guidebook really offers that, what is and what we have to consider when we take that first step. Chantal did say that, ideally it would be the best thing for a whistleblower to go to a legal advisor or a legal counsel before blowing the whistle. But now we're dealing with cases where people didn't know any better. Should they be punished for it? I mean, it says that not knowing the law is not an excuse, right? It's not an excuse at all. But what about those who really just, blew the whistle and they didn't really know the law? I mean, some of these sections that I've got to learn about, I only got to learn about them when I was reading the draft. So what happens in those instances when people are not lawyers and yet they are expected to do right? But in doing right, the only remedies that they have, it's legal, and they're not lawyers, right? So we will definitely try and raise awareness about the guidebook and what benefits are in the guidebook. And if there's anything that we've left out, please do not hesitate to send us an email or a message on Facebook. just so they can consider it. But if you think so far what we have is a robust guidebook that can go a long way, can you please just clap your hands one more time for Chantal and Zine? Thank you very much, ladies and gentlemen. You can go back. And as we're about to wrap up the today sessions, I will call Kate actually to give the message, solidarity message from ACM. So it was her, the person we were missing earlier. And then I'll also close by reading a message from Public Interest South Africa as well. And then we will let you go home or back to work.
Yeah. I just want to say once again, thank you to my colleagues. They did an excellent presentation on whistleblowers, and unfortunately, there weren't sufficient whistleblowers around the room. They would have definitely have benefited from it, but not just them. I think employers should have been present as well, so they can fully appreciate the law in terms of protection of whistleblowers. All right, let me get to what I'm actually here for. On behalf of Active Citizen Movement, they stand in unwavering solidarity with the courageous whistleblowers who have risked it all to expose corruption and malfeasance in South Africa. Their selflessness of bravery are the bedrock of accountability and justice. We have seen these patriots suffer, and we remember Babita Deokaran, who paid ultimate price for her dedication to the truth. It is a reminder of the immense sacrifices made by those who shine in light on wrongdoing. As we gather for the PLAF Whistleblowers Protection Week, let us recommit ourselves to the cause of strengthening whistleblowers legislation, ensuring that these heroes and heroines are not only supported and protected, but celebrated for their sacrifices. In this spirit, we must continue our tireless efforts to create an environment for whistleblowers and hold those who endanger them accountable. Together, we build a South Africa where truth and justice prevails. Solidarity and strength to all whistleblowers. Thank you.
Thank you very much. Thank you, ACM. And now on behalf of Public Integrity South Africa, this is from the chairperson, Mr. Tebogo Kass. And he wrote, on behalf of Public Interest South Africa, I extend our wholehearted support to the PLAF, Gibbs, and the Friedrich Naumann Foundation for organizing the 2023 Whistleblower Protection Week at Gibbs. It is commendable to witness the collaborative efforts of PLAF, Gibbs, and FNF and other civil society organizations in addressing the critical issue of whistleblowing, especially against the backdrop of the proposed amendments to the Protected Disclosures Act. This event holds particular significance as it provides a platform to delve into the legal aspects surrounding whistleblowing, fostering a deeper understanding of the current legal landscape. We appreciate the emphasis on the development of a legal guidebook for whistleblowing, a resource that undoubtedly contributes to empowering individuals to navigate the complexities of whistleblowing laws effectively. Such initiatives align with our shared commitment to promoting transparency, accountability, and ethical practices. As an organization dedicated to the betterment of society, we recognize the pivotal role whistleblowers play in upholding these values. Their courage in exposing wrongdoing contributes significantly to the enhancement of our legal systems and the preservation of ethical standards. We wish the organizers, participants, and attendees a highly successful and impactful Whistleblower Protection Week. May the discussions and insights gained during this event contribute to the ongoing discourse on whistleblowing, fostering a culture of accountability and justice. We look forward to the positive outcomes that will undoubtedly arise from this significant gathering. With warm regards and immense appreciation, Tebogo Kass, Chairperson, Public Interest, South Africa. Thank you. And with that, let me take this opportunity to thank you for taking the time. We don't take it lightly to sit here for at least 4 hours. It shows commitment, it shows support, solidarity, even with what we're trying to do in building a culture of whistleblowing, but not just whistleblowing, but protected whistleblowing. Because at the end of the day, it's about one of the most sacrosanct right? The right to life. We do not want to see the Peñas, the Moss Parkwes, and the Babitas, happening every week or every year. We don't want to see Matumas who are unemployed, Mtabisi who's here as well this week, and most of the whistleblowers here who are unemployed, and most can't even get jobs because they tried to do the right thing. So thank you for taking your time and showing that support. Tomorrow we're here and we're going to have a panel discussion where Cynthia from Whistleblower House will actually moderate that discussion with about 4 whistleblowers who will share their experiences and what we can take from their journey. And I think with the backdrop of the legal or the legalities of it, they may actually also maybe reflect on what they wish they could have done differently if they knew what they know now and what they can say to other potential whistleblowers not to walk the same route. So thank you very much and have a good afternoon.